Lordship, today's cause list item number 20, Your Lordship. I seek an adjournment for 2 weeks in the matter. Item 2020.
For 2 weeks.
For 2 weeks.
Yeah, for a petition.
Petition.
2 weeks. Adjournment for 2 weeks. Okay, we are listing it after 2 weeks.
Lordship. May I please, Your Lordship, with respect to item number 1 and 32 of the daily list, and for the NCBA file our objection that is not on record. So, Lordship,
1 and 32.
1 and 32. That may be called for.
1 and 32. No? In both the matters you have filed.
May I please, Lordship, I beg to mention item number 37, Lordship.
Oh.
Lordship, CD is not there, Lordship. I am on interim, Lordship.
CD not available, Lordship.
CD not available. CD not available. Issue reminder. Interim be extended till next date of listing. When it can be listed? Thus,
After the
From Nagaur, Lordship,
maybe after Bihu also.
after we.
Bihu.
Interest there, Lordship.
Yes, interim is. Interim will be continued till next date of listing. Bihu, after Bihu, any date?
23.
23. Okay.
May I please, Your Lordship?
Hmm.
37. Obliged, Lordship. May I please, Your Lordship? I beg to mention item number 30, Lordship.
30.
Yes.
Hmm.
The matter will be adjourned for the day, Lordship, and the same will be fixed after 2 weeks, Lordship.
It says charge sheeted case ID.
Yes, Lordship.
Scan copy receipt.
Scan copy received. No? And a request made by so and so. After 2 weeks, you need? Yes, after 2 weeks. Okay.
Wait, please, Your Lordship. Lordship, I beg to mention a bail application for listing for bail hearing, my lord. I'm mentioning before this honorable court because it was earlier rejected by Your Lordship. That order is annexed in my petition.
So it's okay. It will come before me only. Maybe it'll be
my
before
lord,
this
my lord.
bench. But make a mention before the court number 3 only.
Lordship.
Just mention it.
Lordship, deeply obliged, my lord. My lord, I'm seeking some accommodation with regard to item number 31, my lord. Regular bail application, my lord. LCR is here. Lordship, there's one small verification which I need to make instructions from the client as to regard to the service of the notice under 47 and 48 of BNSS, my lord. Those mandatory. So, my lord, I may bring the instruction from my client, my lord. May it come up on Friday or Monday if Your Lordship permits.
Friday may not be possible.
Then Monday, my lord, because my lord, I'm instructed that the grounds of arrest not mentioned, my lord. The Lordship has already held that, my lord, the mandatory.
She's saying that after 1 week it will be only listed after 1 week.
Next week, my
Date
lord.
next week.
Next
Yes.
week. As per
After
Lordship,
that.
obliged, my lord. 31, my lord.
Yes.
May I please, Lordship? I beg to mention item number 29, Lordship. The same may come up after 2 weeks, Lordship. Consent of other side is there and interim is also.
You are for the petitioner.
It is,
You have taken consent of the other side.
and other side is there.
Number 2.
You are respond number 2. Interim was there.
Interim is there.
List the request list after 2 weeks. Interim be continued. Yes, list
2 weeks.
listing after 2 weeks.
2 weeks.
Your interim will be continued till next date of listing.
Deeply obliged.
May I please, Your Lordship? It's my beg to mention item number 15, Lordship. Matter will be taken up at 2 p.m, Lordship.
1-5,
Yes,
2 p.m.
yes. Yes.
For withdrawal, Lordship, 2 cases are there, Lordship. Any date, Lordship.
Maybe on Friday also.
Any
Friday.
date, Lordship. Oh, for withdrawal.
For Friday.
My lord, item
Much
number
obliged.
32, my lord.
Yes.
That, my lord, NCBS filed my lord objection petition. That may be called for my.
And we have already. He was submitting.
Mentioning. Oh,
Yes.
hold it. Definitely.
Item 2.
It is Rashid. My 483 application and charge sheet has already been filed in this matter. So at this stage, my humble prayer for this Lordship to call the TCR Malum along with the case there. And maybe fix next week, Malum, if possible. This is my humble prayer at this stage, Malum.
See, next week may not be possible and lots of matters have been already fixed. Actually, lots of requests were there for prior Eid, in fact. So those were already there. And so case is already charged. Yes, when it be fixed.
LCR maybe, Malum. LCR.
Yes, LCR. LCR be called for. Rest you will do the needful.
On 3rd of April, Lordship.
3rd of April.
Malum, let it.
Third, yes, many matters are there on 3rd. Many matters. We have already fixed.
Fourth, Malum.
4th is possible. 4th, okay.
Item 3.
Wait, please, Your Lordship. This is for regular bail application, FIR page 11. The girl was missing.
It's a case of POCSO, I think.
Also edit, my lord. So
Notice
exponent
of-
number 2 is there, my lord. Maybe search for the copies of the PQ.
Yes.
Notice, Lordship.
Notice is to go to respond number 2 through judicial police station routed to the office of the registry and the public prosecutor. No formal notice is required to be served on state respond number 1. Also call for the, is this a charge sheeted one?
No, no.
No, no. How long he is in custody?
And now I has long, my lord, 1.5 months, my lord.
1.5 months.
Around.
Case is registered under section 4 of POCSO.
And
6 also.
4 also. 4, my lord.
4 POCSO. Because notice has to go. So tell us any date.
April.
April, obviously April, otherwise it will
7th of April, Lordship.
7th of April.
My
City,
lord,
city.
It may be, my lord, 2nd of April, 2nd. my lord.
Second and third, most of the matters are second and third, most of the matters have been fixed.
That, my lord.
There you go.
Then 4th, my lord. 4th.
Of
I am the case diary along with medical report also.
maybe it's supported with the medical report. We'll call for a medical report also.
Item 4.
Wait, this is
Yes.
an option. This is also a trial is proceeding manner. Some of the
Yeah,
witnesses
okay.
have been examined. So my prayer, my lordship, in this matter also call for the 6-year along with case diary matter.
Call for the LCR along with the case diary. We take this one for 7th of April.
7th, Lordship.
Will it be 10th of April? Because from 8th month, I'm
Okay, then 10th of
10th of
April.
April, deep of that.
Item 5.
May it please, Your Lord. Yes. NDPS Act substitute letter, my lord, as on today, the petitioner and the accused have been behind the bar for the last 245 days, my lord.
Okay.
So, my lord,
Report may be called for.
the honorable court has granted a co-accused by this honorable court. Co-accused has only been granted bail on the ground of non-compliance of section 47 BNSS and section 52(1) of the NDPS Act, as well as section 67 of the NDPS Act.
Maybe there may be ground, but we have to call for the case.
My lord, my lord.
Whose court dispose of the other petition?
This was disclosed by the Honorable Justice, Honorable Justice Mrs. Midlu Kumar Kolita, my lord, on 10th March, my lord.
10th of March.
I have the order, my lord.
It's not here. Out of same FIR, same connection.
Same affair, my lord, same affair. Delhi, 14 numbers of cases were succeeded.
Itu disile ata Midul Kumar Kolita disposed of on bystander. Oh, acha, registered on bystander, disposed of, it an idea, no? 8 week case niki. 3.243, yeah. Okay. Understood. When it can be?
For the can before Eid, my lord. Can you?
Before it, not possible. Before it, not possible.
On 4th, Lordship. 4th.
Fourth, can it be possible?
7th.
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 Like that.
LCR calculated along with the case diary.
Item 6.
Happy, Your Lordship.
Yes.
This is 483 application, Lordship. And in this case, Lordship, he was shown arrested on 9/12/2024. And on 9/12/2024, the IO filed charge sheet, Lordship. As on today, Lordship, 100 days, Lordship. And FIR will find, Lordship, page 20, Lordship. Where in this case, Lordship, he was implicated only on the basis of statement of the co-accused, Lordship. And
We'll see to that. Let the CD and along with it LCR be called for.
Lordship. Short date may be given, Lordship.
On 8th of April, Lordship.
Short, we don't have such
Eight of
short date. 7 or 8 we can give
8 of
it at best. 8. 8 you were saying? 8 of April?
8 April.
8 April.
Deeply obliged.
7th.
Kindly pass over the timing.
Timely.
Timing.
Okay.
Item 8.
May please, your lordship, it is a short, matter. Under section 21C, 29 of NDPS Act, matter. At this case, I paid it for updated scan copy of the LCR and with confirm.
How long he is in custody?
Is 319 days in custody.
319
days.
CD along with the case diary be scan copy of the CD along with the case diary be called for
8 of April.
8 of April. Okay.
The LCR, my lord.
LCR we are calling for the LCR.
Hello, my lord.
Item 9.
Nine, what is case? 9 is?
POCSO.
9 is also POCSO. None appears on call, list after 1 week. For the petitioner.
Item 10.
May I please, your lordship?
Yes.
POCSO case, lordship, notices to go
POCSO?
respondent number 2, lordship.
Oh.
Let's have a minute.
Notice for it.
Statement due to complete.
8 of April. 8.
Appropriately statement to complete.
Otherwise, it is a charge sheeted one or not
No,
yet
no,
charge
no,
sheeted?
no.
Not yet charge sheeted. We're calling for the case diary and notice you take steps within 1 or 2 days through office of the, through the additional police station routed to the office of the registry and the public prosecutor. This is the procedure now.
Yes,
So
yes,
then
yes,
in
yes.
that case, public prosecutor can make an inquiry regarding the service of notice.
Yes, lordship, I will submit the order.
Okay.
7.
7th of April.
Deeply obliged.
CD. Here CD only, not the LCR. It's not charge sheeted one.
11.
Similar case, lordship.
11 also. For the same accused or
This is my accused in one, but the FIR is same.
FIR is same. Other one is Sattam Hussain, and this one is Deputy Mangal. No, sorry. 11, na?
11, lordship.
Mintu Kakoti.
Into Kakoti.
Kakot. Kotoki.
Sorry, same date, 7/4. Okay. Same order, same date, 7.
Deeply. CD along with medical report, lordship. There is question of the medical.
CD along with the medical.
Deeply.
Item 12.
Please, your lordship. Lordship, notice may go and case record may be called for charge-sheeted, yes, lordship.
Charge sheeted POCSO.
POCSO, lordship. Special case number, sessions special case number 311 of 2020.
Oh. LCR along with case diary. Our notice to go is to respond number 2, same order. So it will be fixed on 8 of April.
Lordship. Oh, lordship.
14.
Please, your lordship. 483 applications, POCSO is there in around
POCSO is there.
for 55 days in custody, your lordship.
POCSO section 4 or what?
Four,
Section 4.
Section 4 is there. your
How many days? 50 days.
Around 55 days, your lordship.
55 days in custody.
Yes.
Notice has to go, so that's why we need at least minimum 10 days. So if we did, we count it also in that case when it can be fixed. Maybe on 7th of April,
On 9th, your lordship.
9th of April. Okay.
CD.
CDB call for 9th of April and issue notice code to the respond number.
Obliged.
14.
Thing is not here. 14 is also POCSO.
NDPS, lordship.
It's a NDPS.
20.
Charge sheeted one or not yet charge sheeted? Not charge sheeted, I think. No, oh, no, charge sheeted, I think.
Not charged.
Not charge sheeted. None appears on call for the petitioner, list after 1 week.
16.
Madam, POCSO 8, madam.
POCSO is there.
POCSO 8 is there, madam. Case diary and notice, madam.
It's not charge sheeted case. How long he is in custody?
11 days, madam.
11 days.
11 days.
We can
Not
give
long.
10th of April. We're giving you 10th of April.
Oh, okay.
Take steps for the response number 2 through the additional police station routed to the office of the registry and the public prosecutor. So it will be listed on 10th of April. We are also calling for the case diary.
Okay.
17.
That is your logic. 17 and 19 is out of the same FIR. Both may can be
17 and 19.
19. Same
19.
19. Same may be taken up together, Lordship. Here, what has happened? Here, 27 grams of brown sugar, that is heroin, has been seized, but not from my custody, Lordship. My humble submission is it is not from my custody. And most probably, Lordship may kindly come to page number 19. Why I'm showing page number 19? Page number 19 is notice under section 47 BNSS, nothing mentioned. No ground mentioned. We are squarely covered by a judgment of this Honorable High Court. Lordship may kindly have a look. Here, bail has been granted on this ground itself that no provision of 47 has not been complied with. That your Lordship will find in paragraph number the requirement of informing a person in 26, your Lordship may kindly have a look.
Era 26.
Para 26. Ground of arrest must be provided to the arrested person in such a manner in that sufficient knowledge of the basic facts of the constitution constituting the ground is imparted and communicated to the arrested person effectively in the language which he understands. The mode and the method of communication must be such that the object of constitutional safeguard is achieved. Now, Lordship, please come to 27, next page. In the instant case as discussed herein above, the arrest memo as well as the notice served upon the arrestee under section 47 BNSS nowhere mention the grounds of arrest. It only mentioned about the case number in which the arrest has been made and the penal provision which the case involves. Same thing has been done here also. Nothing is there. Lordship may kindly see. Annexure 3, page number 19, Lordship. In both the case.
This is notice.
Notice.
And the other forwarding report and all we have annexed.
Forwarding is there. Forwarding is there.
Where's the forwarding you have annexed here?
Forwarding I have annexed, Lordship. Annexure 2, Lordship. Annexure 2, page number 17 to 18. That I have annexed, Lordship.
Lordship, the ground of our arrest has been communicated to them as well as her relatives by serving notice. It is mentioned here.
But 47, annexure 3 says nothing. Annexure 3 says nothing. And this judgment is on annexure 3 only. The 3 says nothing.
See, there are judgments where in that if grounds of arrest were not communicated, that may be a ground for bail, that is understood.
Absolutely, Lordship.
But 47, communication was how it was done. It is obviously from your record, it is seen that one notice is there without any mentioning anything and in regards to the. Okay, we'll see to it. Both same, all do two,
Yes,
two are same.
Both are
So
arrested from the same place.
coordinate benches that relied some this
Yes, Supreme Court judgment is there.
Supreme
Lordship.
Court judgments
yes,
of
Lordship, it's
Vihan
there.
Kumar and State of Haryana.
Yes,
etc.
yes. Vinay Kumar versus State of Haryana. And Prabir Purkhasta versus State of N.
Prabir
City of-
Purkhasta is also there.
Yes.
Yes.
Two
Is
citations.
it a Prabir Purkhasta mainly deals with This one, grounds of arrest
Grounds of
in
arrest.
the forwarding Audit at the time of arrest, but the notice, I don't know, notice,
Notice is in,
maybe,
Vinay
maybe
Kumar.
Bihan
Bihan
Kumar, Bihan Kumar,
Bihan
maybe
Kumar.
I have to see it.
Lordship.
Okay, then I'll pass the order.
My only,
Yes, any other submission?
no, nothing. If Lordship will pass the order, then I leave it up to your Lordship.
Okay, we'll see to it and pass the order. Both the matters are same. So
Same.
how long they are in custody?
2 days, 32 days, Lordship.
32 days in both the matters,
Both the matters.
out of same FIR.
Same FIR.
Okay,
Developed
we'll see
like
to it.
Only my request, if your Lordship calls for the case diary, then Lordship may kindly call it on 28 if possible, because they are having their festival on 1st of April, Lordship. 31st. Eid is on 31st, that is why I'm praying if,
So you are praying for 28.
yes, if your Lordship wants to call for the case diary, make up a mind for calling of the case diary, then I'm praying for 28, Lordship.
Okay, I'll just mark it.
Developed like Lordship.
Try this one. This was never come up. দুইটা অর্ডার কারণে আছে actually what had happened we I think we will go first. Grounds of arrest regarding the grounds of arrest in that the Supreme Court here as per the grounds of order it was communicated to so so communicated but the notice says nothing. So one judgment is Bihan Kumar, where the notice is also there. You go by the order. I mean, you see the order sheets and the observation journal. Then you pass the order, you fix the case diary also. Let us see.
Very good, Lordship. Lordship, 54 is behind the bar, Lordship, and sections are so serious, Lordship. Schedule call for Lordship. Response Soika, Lordship, come from district, Lordship.
I'm sorry, I started.
Sorry, Goremari.
So it is registered under UAP Act. in
Yes,
fact.
that is also there. Again,
How long he is in custody? you are saying?
54 days, Lordship.
54 days.
Yes, Lordship.
Yes, that's when it can be fixed.
On 28 March, Lordship.
20th March, we have lots, in fact. Yes, if it can be 4th of April only.
Right, problem.
53 of the supplementary list.
The CD call for it. 50?
Please, Your Lordship.
Yes.
This is a regular bail petition, my lord. FIR is at page number 9, my lord. And today's 10 days, my lord, I was behind bar, and the mandatory period is 60 days, my lord. From page 9, from 10, my lord, the FIR contention is from 10, my lord. May I read, my lord? Most respectfully begs to state that I am a student of degree 2nd semester studying at Haji Anaf Ali College, Doboka, and belongs from a very poor family. Sir, yesterday, that is on 6th of March at 9:30 a.m. I walked from home to college. Due to the month of Ramzan, the streets are empty. The accused then blocked my way and asked me various questions. Normally, I was answering, but suddenly he hugged me and touched my private part. I immediately assumed that the accused had done this with the intention of rape. Then I screamed, and the accused left me and fled on his bicycle. So if we cannot go to school and college safely and securely in daylight, then that is a big question mark over law and order. So, my lord, actually, what happened, my lord, there is a love relations between the petitioner and the informant, and petitioner is ready to marry the informant. But what happened, my lord, as she is studying BA, therefore he asked the family member of the informant to wait until completion of the her course. But suddenly, my lord, family member of the informants were pressurizing the petitioners to marry her immediately. And on such pressurizations, the petitioner said that, okay, I will marry her, but after give me 3 months, because at presently my financial condition is not good. So on that day, my lord, there is a quarrel between the informant and the petitioner in front of the bicycle garage of the petitioner, my lord. And on that thereafter, my lord, the petitioners told the informant that if her behavior will not change, then he will have to think again about their relationship. Thereafter, his FIR was logged, my lord.
Maybe your submission may be true, I don't know, because there may be a love relation also, but the FIR FIR is a bit, confidential is very serious.
Still,
Otherwise,
make it a bar, my lord.
it's a not a, I think it's not a case of POCSO, I think.
No, major, my lord.
She was a major.
Major, BA second semester student, my lord. So, due to this, my lord, conflict, this FIR.
But yes, even if he is major, whether it's required. Like POCSO is required, but 376, what about 376? It's an attempt, not 376, one attempt.
Harassment, my lord.
Okay, then we are calling for the case diary then.
If possible, my lord, before the Eid, my lord, if possible, my lord, from.
Before it may not be possible because we have lots of matters, 27 parini ki baat hai.
It's from Murazhar Huzai, my lord.
Ho jaye.
Yes, ma'am.
26 we're giving. We'll try if
My lord.
CD comes only. Okay.
It lacks favor, my for my line, my lord. Hello, bless.
Time being item 1.
Mallam 1 and 32 from the same FIR, Mallam, same day arrested, maybe taken up.
Yes, they have already filed, I think.
Yes.
Yes, yes.
May I please your receipt, kindly pass over the matter for the timing.
Yeah.
My senior will appear, Your Lordship.
Yes, his senior will appear, I think. It's a case of otherwise commercial quantity.
Well, at commercial quantity, in fact, what happened, there are 6 accused person. It was recovered from 1 and 5 were arrested from a separate vehicle. Now, out of these 5 accused person, 3 are granted bail by this honorable court. And the other 2 is, item number 1 is 1 and 32. 132, there
Who
are,
granted by the way bail?
bail was granted by a coordinate bench of this court, Justice Kolita.
Can it be better in this way?
Yes, yes, Your Lordship. The new notification is that if the
New notification is there, I have seen.
if the judge is out of is in a
Is
outline
out of station.
yes,
there,
out
no?
of station, outline bench.
Outline bench. Your senior, what time would we
Lordship,
fix
at
it?
2.
You want to fix it at 2? Both 1 and 32? We're fixing at 2 because his senior may come. You have already received the objection filed by.
Yes, yes, yes.
Much obliged, Lordship.
Okay, it is.
21.
32, na? 8 or 8, 1 and 32.
Yes.
Okay. Thank you.
May I please, Your Lordship?
Yes.
Lordship, in this case, Lordship, NBW was issued, Lordship. Actually, what happened, Lordship, I was participating in the trial proceedings, Lordship. Out of 3 accused, Lordship, 2 accused are still in jail, Lordship. They have no guardian to apply bail. So, Lordship, legal aid applied recently, Lordship. So, in the meantime, Lordship, what happened, Lordship? Trial court was vacant for long, Lordship. Additional 5. Kamrup Metro. So, Lordship, having no other option, I'm a daily wage labor, Lordship. I had to go outside, Lordship, for my livelihood. So now, again, Lordship, as earlier I was appearing, now again I want to appear, Lordship. I want to participate in the trial proceeding. So my only prayer is that, Lordship, NBW may be recalled.
Why NBW? If you are appearing, why NBW was issued?
Because, Lordship, court was vacant, so I did not in that period, Lordship. I was not.
You have annexed the order sheets, all order
Yes,
sheets.
yes, Lordship. I was not appearing regularly, Lordship. That is why NBW is page number 10 and 11, Lordship.
10 and
11. Fix tomorrow, Lordship.
So you are Sunil.
Sunil. I was in regular bail and I was appearing also, Lordship. But thing was that, Lordship, court was vacant. So every day my date was fixed along with that judicial custody accused, Lordship, production.
We have not annexed the earlier orders and orders. I mean, we want to see that you were earlier, you were regularly appearing.
Before this, then, Lordship, I was regularly,
That's what I'm just asking you, whether you have the order sheets.
Lordship, I have not annexed it, but Lordship, that website, Lordship, it can be seen, Lordship. But I have
Okay,
not
then
annexed it.
we will fix it at 2 because we need the order sheets. You are saying, you are repeatedly saying,
Produce the orders in my lord.
that's what I'm
What
saying.
reason my lord, he has, NPW has been issued for.
Lordship, this was the date.
Because you are saying repeatedly that you were
Yes.
regularly appearing.
Yes, Lordship.
As because the PO was on transfer or vacant, court was vacant.
Vacant.
Obviously, I also, it is within my knowledge also, court was vacant for a considerable period.
Yes, Lordship.
That is understood. So
Right.
that's why I'm asking you, these are not here. To see your conduct, in fact, that whether you are paying or not.
When I took this certified copy, Lordship, this was the date, Lordship, from which this was the first date, 11/11, when NBW issued. From this date onwards, I was absent. Before that, Lordship, I was regularly present. And
That's what I'm saying. You are not.
That's it.
trial is going on, Lordship. It's fixed for evidence.
Lordship may call for them and scan copy, my lord. We'll produce the scan.
What I'm saying that you are saying to, you are regularly appearing on 11/11, only the first day when your NBW was issued. So we want to see your conduct earlier, that if you are regularly appearing, that may be a case for bail also.
Lord,
That's what I'm saying. That's why.
actually, date is fixed tomorrow. So, Lordship, if Lordship allows, then
Tomorrow, what can we do? We have
Yeah.
filed today only.
then again I have to.
You have to somehow you have to manage or do
Either he will
something.
produce the my lord certificate copy or Lordship may call for the scan copy of the record.
You can produce the certificate copy also. Because tomorrow, I don't know. Tomorrow it may be fixed. I don't know when it may be. Tomorrow, lots of matters have already been fixed.
Tomorrow, day after tomorrow, Lordship.
Day after tomorrow, that is on Friday. Day
Monday
after tomorrow
is
is
also okay, Lordship, Monday.
Monday. What is the date? Monday? 24. Yes, we can fix it on 24. You just either we are not going to call the then just we have filed an additional affidavit through that all the annexed all this.
All the orders or just 2-3 orders of previous day, Lordship.
Now see to see your conduct is cases of which year?
Cases of 2021, Lordship.
21.
21.
So at least you submit some of the orders so that your conduct is that you are regularly appearing. That has to come, na? That's why I'm just asking you.
Lordship.
So we are fixing it on Monday. You try to furnish all these
All
things to order sheets through an additional affidavit. 24. 24th, na?
Yes. Twenty-two.
Lordship, my senior is on currently lag. Can you pass it for the time being? And you're on lag.
23.
22.
22.
Yes.
There are lots of matters have been timing. I don't know it may reach or I don't know.
Currently on lag, so advise me.
Okay. We are fixing it on time.
Much.
23.
It's 23.
Yes. May please the lordship. Lordship, in this matter, the respondent number 2, the private respondent, has lodged an FIR before the Jorhat police station under section 498A of the IPC against her husband and the family members of her husband. Lordship, Lordship, what has happened in this case is the respondent number 2 has got married to her husband in the year 11 July 2007. And subsequently, Lordship, I am the petitioner over here. I have been married to the brother-in-law of the respondent number 2 after about 7 years of their marriage. Lordship, after the respondent number 2 got married, she shifted. Lordship, I am residing in Bikaner, Nokha currently, and throughout my marriage, I've been residing in Bikaner, Nokha. And now, Lordship, since after the marriage of the respondent number 2 shifted to Jorhat after that, Jorhat, Assam, and she's been residing ever since there only after my marriage. Subsequently, Lordship, what has happened, respondent number 2 has lodged a FIR before Nokha police station.
Nokha?
Yeah, yes, Lordship, Nokha, Bikaner on 16/11. 16/11/2023, Lordship. And after that, Lordship.
She got married on 2007.
2007, and now she has filed for
Lost FIR on 2023.
23 before the Nokha first FIR. She has filed two FIRs, Lordship. The first FIR she has lost in Nokha police station, Bikaner, in 11 July, 16th November 2023, and subsequently now after she lost the FIR in Bikaner, she shifted to Jorhat, and now she has again lost the FIR in Jorhat police station for the same cause of action under section 498A itself. If your lordship may look upon the complaint, the FIR lodged by the respondent number 2 at page number 43.
Yes.
Apology, Lordship. Lordship, at page number 50. It's about the Nokha police FIR lodged in the Nokha police station. Lordship, in this FIR, I have not been arraigned as an accused.
No, 50 before Nokha police station.
50, page number 50.
Is before Nokha police station.
Before Nokha police station. Herein, Lordship, I have not been arraigned as an accused, and no allegation has been raised against me. In this FIR.
No, you are how you are related. You are the sister-in-law.
Yes, Lordship.
Okay.
I'm sister-in-law, and my name is not even mentioned in the Nokha police station. In the same, it is filed under the same section for the same cause of action between the same parties, Lordship. Though my name or no allegation has been raised. Subsequently, when she shifted to Jorhat, she has lodged another FIR wherein she has again arraigned all the accused, and now my name, after 2 years, she has arraigned me as an accused, Lordship. And before the Jorhat police station, Lordship, in the complaint, there has been no allegation been raised against me. There is no specific allegation. Just a general term has been used that the family members has been doing it. That the family members has been harassing and torturing me. No,
Where is the FIR? Now present FIR?
the impugned FIR is at page number 43.
43.
Yes. Lordship, the type copy is at page number 47 of the complaint. If your lordship is there.
Yes, yes, I have already.
At page number 47, what is the complaint which has been filed by the respondent number 2 is, with due respect, I humbly submit that on 11 July 2007, I was married to a aforementioned opposite party number 1, according to the Hindu rites and custom. After 2 years of marriage, on 22nd April 2009, a daughter was born to us. Since the birth of my daughter, the aforementioned opposite parties have been demanding dowry in cash and have tortured and harassing me in various ways. All the opposite parties together have started to treat me like a servant and try to make me behave like a woman without any status and dignity. Even with an illness, they do not provide any medical treatment. They do not let to eat on time. Thinking that everything would be all right in time, I did not file any case against the opposite parties. On 5 June 2023, the opposite party number 1 went to Digambar Chowk, Jorhat, to meet Avanti Devi, who stays in the rent. Amarchand Rathi, the lordship, this Amarchand Rathi is the husband of respondent number 2, tried to strangle me and my daughter to death. The opposite party number 2, that is my brother-in-law, Ghansham Rathi, gave me obscene gesture at various times, and when I did not agree, he threatened to kill me. On 23rd November 2023, the members of the Assam Bir Lachit Sena rescued me from my husband's house in Rajasthan and brought me back to the Assam. My husband did not care about my and my daughter's whereabouts for a long time, Lordship. This was the complaint been raised. Lordship may see that there has been not even a single evidence, not even a single statement or any evidence or material evidence on record which has been brought by the respondent number 2, which is stating that I am involved in this offense. Just a general, my name has been arrayed in this party. That's it, Lordship. And Lordship, apart from that, the contention which was made by the respondent number 2, that Assam Bir Lachit Sena has rescued her.
What is the stage of the case at present? Is it charge sheeted one or not yet charge sheeted?
Not charge sheeted one. Lordship,
is there any interim prayer from your side?
Yes, Lordship, an interim
kind
protection may be granted since I am staying in Bikaner, Rajasthan.
So have you filed any anticipatory bail in this regard? No.
No, not filed in.
Yes.
First and foremost, my lord, then my learned friend, the directed to my funded the complete page of the FIR, my lord.
Oh,
Proceed, may kindly see my page number 46, my lord. This is the vernacular one, my lord. But I
46.
46, my lord, if I am not mistaken, my lord. 44, 45, 46, my lord. This is the vernacular one, my lord, FIR, my lord. Only for the half page, my lord. The complete FIR is not available, my lord.
No,
Copy
in
part.
my copy, 46A.
This one, the complete civil number.
46AB is there or here's just 46?
Only 46, AB is not there.
Oh, it's on here only 46,
So let me
46A.
furnish the complete so that I can go to the FIR, my lord. What are the ingredients?
Lordship, there
And check-
might have been some minor clerical issue with serving of the copy that's this last two pages might not have been there. But Lordship, in those two pages, there's nothing specific allegation.
No, from your side, it may be nothing, but in the second page, I have seen there's a lots. 46A and 46B, it is here only, we are in a record, it's
Yes.
here. But its copy is not there. So, but 46A is the main allegation. So he has to go through. That is his contention. I don't know, it may be fixed.
Furnish and let the matter come up day after tomorrow, my lord.
Day after tomorrow, you're here. So you're from outside station or from
Lordship,
Guwahati itself?
Guwahati itself.
Okay, then day after tomorrow, we are fixing it on simply day after tomorrow. It's just furnish the complete copy. Tomorrow may not be possible. Lots of matters have already been fixed. So day after tomorrow and Friday we can.
Monday, my lord.
Yes, your purpose or convenient Monday or Wednesday?
Friday, Lordship.
Friday.
Monday, there's some other matters being listed.
Okay, then Friday we are listing it. Just furnish the complete copy of set of this FIR so that he can go through and
I'll
just.
furnish Lordship.
Okay, then that's possible. Yeah, I have already understood what I have said.
Lordship, my prayer for interim prayer may be considered in the next date.
No, that I cannot say. Let him submit.
It's
See.
that is to, my lord, to study investigation, my lord. That, my lord, I
See, the investigation is not
Yes.
possible. Other prayer, let us see. If it
Lordship,
can.
no coercive action may be taken against me.
No, whatever, we're not passing the order.
Yes.
Just pass the order on 20 Friday. We are fixing it on Friday.
Much obliged.
Friday, not anything.
21. Twenty-four.
Lordship, my senior is late on another court. Kindly allow for time being.
Now, see, there are lots of time being matters. It may come or may not also. Huh? I'm just letting it as time being. Let us see. Okay.
25.
Time being, lots of pieces of
May I please, Lordship? Lordship, this is Segbound's case, Lordship, and the Lordship in this case, the learned court below has issued non-bailable warrant of arrest against me on 21/9/2022. Lordship, kindly peruse page number, Lordship, 23.
Page number 23.
Yes, Lordship. Lordship, actually, Lordship, I am just suffering from a tuberculosis and since a long Lordship. In the case for Lordship, I could not appear before the court. And the Lordship, my counsel who appearing before the trial court, he did not file any petition. And on that, the Lordship, the learned court below was issued a non-bailable warrant of arrest. And the Lordship, thereafter, Lordship, so many days gone, Lordship, but I did not appear. And on 18/3/2023, Lordship, proclamation was issued. And the Lordship, there is another case which is pending before the same court, Lordship, and 41/2023.
So you are absconding since long, I think. No.
Yes, Lordship. But
Then
Lordship,
what is your explanation?
Lordship, I was suffering from a tuberculosis.
That is understood. Since
Yes,
there may
Lordship.
be a period wherein you may be seriously ill, maybe I
Yes,
won't
Lordship.
disagree with you because
Lordship, I
tuberculosis is
submit the
there,
medical
but
documents, Lordship.
but after taking medicine, you may have improved also because now already 3-4 years have gone.
Yes, Lordship.
Then?
But Lordship, my counsel did not inform me and I did not appear. And
You know better. Your case is
Yes,
pending
Lordship.
against you. Then
But the Lordship, there is another case which is pending before the same court. And the Lordship, in that case, also the Lordship non-bailable warrant of arrest was issued. And the Lordship, I preferred a criminal petition before this Honorable Guwahati High Court. And considering my health issues, Lordship, the NPW was suspended. And the Lordship, I annexed that order, Lordship. So kindly peruse the Lordship, page number 42, Annexure 21, Lordship. Lordship, this case is filed by the learned trial court, Lordship. So kindly peruse the annexure 21 Lordship. Page number 42. Lordship, in that case, also Lordship, the NBW was issued, and the Lordship, considering my health issues, Lordship, the learned body High Court Lordship, and suspend the non-bailable warrant of arrest. And the Lordship, I appeared in that case, Lordship. And the Lordship, this present case, Lordship, kindly peruse, Lordship, page number 40, Lordship. And this case has been filed by the learned trial court. And the Lordship, the condition is there. The page number 40. The 22/4/2024. And the Lordship, in this case, the learned trial court has filed this case. And the Lordship, the ground is that the case record to be put up either when the accused appears or he is brought before this court. And the Lordship, I want to face the trial, Lordship, before the trial court. And the Lordship, this
Case
case has
against
been
you is
filed.
already filed.
Yes, Lordship.
Then why are you waiting so much long time?
Lordship, I was suffering. The Lordship, my treatment is going on before the hospital. Lordship, I was admitted in the Guwahati, Lordship.
What
And
are the
I,
medical documents? Have you annexed?
Lordship, the annexure 22, Lordship, page number 45. Lordship, still my treatment is going on, Lordship. And the Lordship, considering that aspect.
Where is the annexures? Where are the annexures? Medical annexures?
Yes, Lordship, the annexure 22, Lordship. Page number 45. Lordship, still my treatment is going on, Lordship. Lordship, at this instance, I want to face the trial, Lordship. At this Lordship, NBW may be suspended, Lordship. In another case, Lordship, NBW was suspended and I appeared, Lordship. So, Lordship, my humble prayer is that, Lordship, one such may be given to me. And the Lordship, this is Sackbound's case, Lordship.
How many check bounce cases you have?
Lordship, 2.
2.
Yes, Lordship. Lordship, in this case, Lordship, check amount is 3 lakhs rupees. And the Lordship, the trial court has the knowledge that I am suffering the tuberculosis because another is case pending before the trial court. And in that case, I filed the petition. Yes, they will, Lordship.
Oh, sorry. S. David. Oh,
Lordship, possibly my name not shown there today.
S. David. Learned counsel for the petition. This is an application under section so and so in connection with so and so for setting aside and quashing of the impugn orders dated 21/9/2022 till 22/4/2022, whereby the learned trial court below had issued NBWA PNA and subsequently on 22 to you have annexed 22/4/2024, whereby the case against the present petitioner was filed after examining the executing officer. After on the basis of the report submitted by the executing officer, declaring him as an proclaimed offender. It is submitted by Mr. Dewry that the accused was regularly appearing before the court, and the case was also fixed for
Lordship, case is filed, and that is not given, Lordship.
Hmm?
Lordship, case has been filed and that is not given, next that is not given.
now how is that will give?
Yes.
It's not possible. Case is filed only. The first NBW was issued on you against you.
Lordship, 21/9/2022.
21/9.
Annex 5, page number 23.
Regularly appearing before the learned trial court below, but due to his illness, as he is a patient of tuberculosis, he could not appear before the learned trial court below on 21/9/2022, and the conducting counsel also did not take any step on behalf of him, and for which the NBW was issued against present accused petitioner. Initially, the accused petitioner was suffering from tuberculosis, and subsequently, and still today, he is facing, he is having problem of chest pain and cough, and he is still under treatment. Further, he submitted that the NK's counsel also did not inform the accused petitioner in regards to the date fixed by the learned trial court below, for which he could not appear before the court. He further submitted in a similar kind of nature of case is also pending. Before whom it is pending? Before another court.
No, Lordship, same court. Additional Chief Judicial Magistrate, Sibsagar.
Same court.
Yes, Lordship, same.
Before the same court, that is additional CGM Sibsagar, wherein he also obtained the order from this court in criminal petition number 209 of 2025, and accordingly, he, pursuant to the said order, he appeared before the learned trial court below, and now he is facing trial in the said case, which is pending before the same court. He further submitted that the accused petitioner is still willing to appear before the learned trial court below and to contest the case. However, if some interim protection is provided to the present petitioner. Next para. After hearing the submission made by learned counsel for the petitioner, I have also perused the case record in the annexures filed along with the petition, especially the order sheets which have been annexed. On perusal of the order sheets, it is seen that the accused was appearing before the court, and in some occasion he appeared through his uncased counsel, but on 21/9/2022, he did not appear before the learned trial court below, nor his conducted counsel had filed any petition on his behalf. Since then, the NBW were issued against the present petitioner, and subsequently, the court had to issue the PNA against him, and considering the report of the PNA and considering the report of the executing officer, the order was passed on 22/4/2024, and case was filed against the accused petitioner with an observation that same may be reopened as and when the accused is brought before or appear before the learned trial court below. Thus, it is seen that after exhausting all probable steps. After exhausting all probable and all efforts, the Learned Trial Court below had to issue NBWA along with PNA. And on the execution of PNA, the case had to be filed against the accused petitioner, considering the report of the executing officer. Thus, the order passed by the Learned Trial Court below are not found to be are not irregular or illegal. However, full stop. However, considering the submission made by the Learned Counsel for the petitioner, who is stated to be a patient of tuberculosis and other factors, other aspects of the case, I find that one more chance may be given to the present petitioner to appear before the Learned Trial Court below with an appropriate application for bail, which may be considered in accordance with law. Full stop, the petitioner is accordingly directed to appear before the Learned Trial Court below within 15 days. 15 days will do. 15 days from the date of order. Until then, the execution of NBWA be suspended or stayed. Okay. Yes.
Obliged also.
Twenty-six.
Please, Your
Yes.
Lordship, this is an application under section 528 of PNS Lordship for passing of FIR dated 8/2/24. Lordship, FIR is at page 35 and Exhibit 8.
Yes, this is the FIR.
Lordship, may I read the FIR? It is hereby inform you that Sri Deepak Sharma, son of Rajan Sharma, village Chungi Molia, Tamulbari, PS, Titabur, Jurhat, Assam, is a permanent employee of Artfed with the financial assistance of the government of Assam. Yarn Bank was started in August 2019 and 4,316 kg of yarn was supplied to Yarn Bank by invoice with a total value of rupees 21,53,445. Total sale value of the yarn were rupees 12,88,952. According to the audit of the Superintendent's Office, Sodia Handloom and Textile Department, Government of Assam, the supervisor, Sri Deepak Sharma deposited rupees 6,59,000 against the sale proceeds of rupees 6,29,952 without depositing in the bank, which is against the government policy. In addition, according to the audit report, the shortage of yarn was 582 kg and the value of which 4,87,929 rupees. The total deficit, including deposits and yarn stock deficit, is 11,17,891. As per the audit report, Sri Deepak Sharma has embezzled the government fund, and it was registered at Shadia PS case number 9, Lordship, under section 409 and 420 IPC on 8/2/24. Lordship, thereafter, he was arrested on 7th of May 24, and this honorable court granted him bail, Lordship. Thereafter, he was suspended by the department on 25th of June, Lordship. That we have challenged in a writ proceeding during the pendency of the writ proceeding petition, Lordship. His suspension order was revoked by the department on 8th of November, Lordship. Now, Lordship, my humble submission is that the entire FIR was lost due to some wrong calculation in the audit report, Lordship. Lordship, next date, he has appeared in the before the Learned Subdivisional Judicial Magistrate Shadia, Tinsukia. So next date fixing on 3rd of April, Lordship.
I'm not following you. Case has already been charged sheeted.
Lordship.
Then why are you saying that you're praying for quashing of the FIR only?
FIR and charge sheet both, Lordship.
FIR and charge sheet. Yes.
The such that case, madam. So, at the best, madam, scan copy may be called for, madam. Because there are materials against this person, madam. That is why after investigation, madam, substitute has been submitted, madam.
And who is Surjakanta Rava? He is the informant.
Yes, Lordship.
That means we are issuing notice to the respondent when your case is fixed.
On 3rd of April, Lordship.
For what? What stage is?
For appearance, Lordship. He has appeared.
He has already appeared.
Lordship.
It's not so that easy. I think no interim should be at this stage.
That I oppose, madam, because the certificate case, madam, here, since he has already appeared, madam.
Already appeared.
Yes. Lordship may at the best, my lordship can may scrutinize the madam, scan copy of the madam materials.
Case record. And be issuing notice on the respond number 2.
And madam, scan copy of the case diary may be called for.
Yes, obviously. Scan copy of the case record along with the case diary be called for. It will be and also issue notice to the respond number 2 to register AD and as usual process. No formal notice is required to be served. So and so.
Lordship.
If it is in 3rd of April, prior to that, we don't have any date. I think it is 3rd of April now. It is only fixed for appearance only, I think. Then when it can be fixed.
That will be after third only, man.
Can it be
After 2 weeks then?
After 2 weeks.
You want after Bihu?
Lordship, is not passing an interim order. So, Lordship, may I pray before 3rd of April, Lordship?
So notice has to go, my lord.
Notice has to go otherwise. Because he is the informant, I think.
Yes, Lordship.
In absence also, it may be hard, I think, for Borwa. Mr. Borwa,
My lord.
it may be hard, I think, even the
Lordship,
absence
I
of
can serve
informant
the
is there.
notice, Lordship, by Dusty also, Lordship, because they have.
Yeah,
No,
I
it's a-
take it.
He need-
The lordship may fix it on 1st of April.
Okay, we are fixing on first. Yes.
27.
Yes, FIR is page 12.
Yeah.
My lord. In particular case, earlier to that, we lost FIR against them.
Hmm?
To take revenge, that FIR has been lost, my lord. Page 12 is their FIR, my lord.
Yes, page 12 is lodged against you.
My, yes.
Yes. Yes, it is a
Very
very
lots of it-
serious allegation.
My, it also can be page 6.
Page 6,
Paragraph 6.
para 6
Yes,
of your petition.
Yes. Just to take revenge, that one allegation has been.
Okay.
Yes, sir. The petitioner begs to state that Faisal Islam, this is the petitioner one, my lord. He has a well shop near the house of the complainant. On so the dispute arisen between the complainant's husband and the Faisal Islam, which led to a physical conflict wherein the complainant's husband assaulted the Faisal Islam petitioner, causing a hand injury. In this regard, Faisal Islam lodged a complaint in the Kwati police station, and the investigating officer of the state police station registered a case, so and so, madam. On the basis of our FIR case has been lost on, it is 86. After that, my lord, so many days, they lost this FIR by leveling the false allegation started. If you lost, kindly see, page my FIR, my lord, I could not announce the FIR full copy because I cannot go there due to fair money. Page 18 is the FIR. On the basis of that, FIR case has been registered. Then illogically Faisal Islam is the petition number 1, and Shorawal is the husband of the informant matter in present case. So let the interim maybe petition may be given. I also kindly see page 19. Fixer. I have sustained fixer, there is accelerated transmitter. Let the city come, put the case, city put the case, call for. Register, 86. I have done annual. Let's 21. 21, 10. Extortion safety. Let the Buddha city call. Buddha city, Buddha is call. In the meantime, I have already fastened fixer. Due to take revenge, my lord, they have lost this affair, my lord, because we lost the affair earlier. Only for that, if the any materials come, it may be rejected. No problem. Deputy Hospital, call for the case there. What that was.
Heard Mr. G. Ahmed, the learned counsel for the petitioner. And also heard Mr. R.J. Purva, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Ahmed, the learned counsel for the petitioner, that the false and concocted, with some false and concocted allegation, the FIR has been lodged against the present petitioner only as a counter blast against the order, as the wife of the present petitioner had earlier lodged an FIR against the husband of the informant with the allegation of assault on 21/10/2024, which has already been registered as Kaki PS case number 86/2024 under section 296/112 subsection 2/3 subsection 5 of BNS. He also annexed one medical document wherein it is seen that wherein it is stated that the present petitioner also sustained fracture injury due to assault by the husband of the informant. However, he submitted that he is ready and willing to cooperate the IO. However, it is submitted that the petitioner is ready and willing to cooperate with the IO in further investigation of this case if he is provided with some interim protection. Next para, Mr. Borwa, the learned additional PP submitted in this regard that CD for both the cases may be called for at this stage to know the actual fact of the case. Interim detail. Okay, we buy interim protection.
Two petitioners, sir.
Two case diary will be called for.
Yes, and
Eta ase
petitioner
Kaki PS aru eta belega eta jitu present. Itu hoise ago to itu present.
two
Both
petitioners.
case diaries will be called for. 23/4.
Another two petitioners here, madam.
Pardon?
Two petitioners.
One is Faizul and other one.
And this Sarifuddin. Sarifuddin.
Sorry for.
Hello.
28.
Yes.
Section 482 application.
Hmm.
Offense relates to theft and lordship. 7 of PC Act. 7 of PC Act is bailable lordship.
Hmm.
Here lordship petitioner.
Where is the FIR?
FIR is the page 13 lordship.
7.
Page 13.
Page 7.
I think 1-3.
1-3.
Lordship, before that, just I like to apprise this honorable court. Petitioner happens to be a trader and a valid trade license being issued by the panchayat to conduct the same business. And in course of his lawful business lordship, he has transported rice and that has been intercepted by the police of Kirchhoff, and that is at page 13. That is the affair lordship.
May I take your lordship to basically the contents? With reference to subject cited above, I have the honor to inform you that based on so and so, so and so, so and so, a team of active so and so intercepted a truck number so and so, vehicle bearing registration number AS 28 AC 0203 driven by Jalal Dewan, so and so, so and so, so and so, along with handyman so and so, Rustam Ali so and so, district Barpeta, at NH near Gorchut flyover. Flyover Gorchut, suspected to be carrying stolen essential commodity, so and so landed from Barpeta towards Shillong. During the preliminary inquiry, the driver and handyman stated that they were transporting the rice. However, based on our suspicion, we decided to conduct a thorough inquiry of the vehicle for the traffic safety to prevent untoward incident and ensuring the security of the concern. The vehicle was brought in front of the Gorchut fields due to darkness and unavailability of labor. An immediate search at the time of interception was not feasible. Subsequently, at so and so, individual driver Jalal so and so, son of so and so, so and so, so and so, district Barpeta, and handyman so and so, Rustam Ali, resident of so and so, district Barpeta, along with the loaded truck, were handed over to the officer in charge Gorchut field for safe custody. Following necessary arrangement, labor search, vehicle was conducted. Then following page lordship. So this one lordship, the vehicle was intercepted and 240 numbers of rice bags were seized. Vehicle was seized. Driver and this handyman was sent to jail lordship, and has been forwarded to jail. And so a case under section 303, 61 to 370, that is dishonestly receiving, when 7 of EC Act has been registered. Now my contention, lordship, may kindly please to see at page this 15 lordship, his trade license, which I have already referred, trade license, which is valid up to 36/2025, issued by the Gang Panchayat, Sagbur, lordship, in the name of Ishan Traders. So by this, he has been given empower to dealing with rice, lordship, and that makes lordship page 24. 24 is the supply of bill, lordship, that was along with the vehicle, lordship. Is the same vehicle number is given here, lordship. Down below, it was sent to Shillong as referred by police. AS 21 down below of the bill, lordship, AS 21 AC 0203, same vehicle has been. So my contention, lordship, it is a regular course of my business only because of the suspicion they have intercepted and they have seized. Now, my lord, I'm ready to appear, lordship, and produce my documents. And I'm
Yes,
ready
Bora.
to cooperate. I'm ready to cooperate, lordship. So, my lord, I may be protected, lordship, till my appearance before. Thereafter, lordship.
Question is that my driver handyman could not produce any document, my lord. That is why, my lord, the truck has been, my lord, seized along with the, my lord, 240 bags of rice, my lord. You know, let him appear, my lord. Otherwise, my lord, as far as trade license, my lord, trade license and my lord, my lord, receipt, my lord. That will be, my lord, it will be verified by the police only, my lord. Because CS and my lord, whether these are original or not, my lord, we cannot say, my lord. The police has to verify, my lord.
MST Som, the learned counsel for the petition. And also heard Mr. R.J. Burwa, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by MS Som that the accused petitioner is a traders, and he deals with the business of rice and business of rice full stop. The license was also issued in his favor for trading business to do the business, and which was issued on 1/7/2024 and is valid up to 30/06/2025. Further, she submitted that the challan was also up the for transportation of the rice, 240 bags of rice to Shillong. He already produced one challan, wherein the name of the driver is also mentioned as challan. The trade license and the bill of supply is also annexed along with the petition. She further submitted that as the handyman and the driver could not produce the proper document, the police intercepted the vehicle and seized the rice bags suspected to be stolen. She further submitted that the accused petitioner is, however, ready and willing to cooperate the IO in further investigation of this case and to produce all the relevant documents which will be required for the purpose of investigation if he is provided with some interim protection. Next paragraph, Mr. Borwa, the learned additional PP submitted in this regard that at the time of interception, police, the driver and the handyman could not produce any documents, and on basis of which the truck was intercepted along with it 40 bags of rice. However, the petitioner may be given one chance to appear before the IO and to produce all the documents which may be verified by the investigating officer. Next paragraph, considering the submission made by so and so forth, to detail. Okay, you'll be under interim protection. When it can be fixed?
21/4.
21/4. Appear before the IO within 7 days from the date.
Can it be on 24/4?
24/4.
2 days.
Okay,
I'm deeply obliged.
24.
54 of the supplementary list.
The FIR, my lord, is at page 11A, my lord. The dispute
FIR is
between
at 11A.
11A. Dispute between two brothers for ancestral property. My lord, may I read, my lord?
Yes.
With due respect, the undersigned wish to inform as follows. Both of us stay and work abroad, currently stay in Hamilton, New Zealand, with professional activities in other countries too. We arrived in Guwahati on 28 February 25 after visiting Mahakumbh and stayed in our residence at so-and-so, Shantipur, Guwahati. On 3rd, it should be March 2025, we visited our mother-in-law's house at 30 so-and-so. However, we could not meet our mother-in-law. Informing the visit of ours, we called our mother-in-law today morning at 6 March 25 for visit in the evening. Around 5:30 p.m. dated, that is on 6 March, we visited our mother's house at Gandhigosti. At the Gandhigosti residence, our mother, who is living with her younger son, Prasanto Sharma, he's the applicant here, my lord, who was always threatening Dr. Diganto Sharma, first signatory below, with dire consequences to kill him if he visits a Gandhigosti residence. Therefore, only Momi D. Sharma, second signatory below, went inside the house. Mother Anima Sharma asked Momi to bring Dr. Sharma to the house instead of meeting inside the car. When both the undersigned is busy sharing it should be experience, my lord, experience of Mahakumbh and other experiences, Mr. Prasanto Sharma attacked Dr. Sharma from behind the back, holding his long hair, and pushed him to the floor. When Dr. Sharma resisted falling to the ground by holding a metal stool, Mr. Prasanto picked up another metal stool and hit Dr. Sharma, that resulted in physical injuries to Dr. Sharma, attempting to kill him. When Momi D. Sharma tried to remove the metal stool, Mr. Prasanto injured her too by twisting her hand. With the intervention of the mother, Anima Sharma, Prasanto left the room and thereafter both so-and-so. Appeal, my lord, will see. Based on the above current incident and continued threatening of Prasanto to kill Dr. Sharma, recorded footage may be so-and-so, since the last 10-12 years, and based on earlier FIR at Chanmari, it should be police station, sometimes in 2012, evidence will be produced when necessary. Both the undersigned request Assam Police to register an FIR for annual judicial action. This I could not understand, my lord. Since both of us, particularly Dr. Sharma, needs to visit Guwahati quite often, Assam Police is requested to protect his life. So this, my lord, the earlier FIR referred to, I have annexed that, my lord, from page 14. So, my lord, may directly, this is in 2012.
My lord, may
The earlier FIR was also there.
it was there, my lord. I have been acquitted after trial. I have annexed the e-courts, my lord. I do not have the certified copy of the judgment, my lord. But my lord may come to page 16. This is taken from the e-courts. My lord may see in the middle case status, 14 November 2016 decision date, contested acquitted. I've been acquitted there. And my lord, actually, the elder son, the FIR informant, he went to attack my mother. Both of us are brothers. I resisted, my lord. I tried to prevent him from attacking our mother, who is aged 85 years. And in the process, actually, I had sustained injuries, for which I had to undergo treatment in Guwahati Medical College. My lord, I have annexed the advice slip at page 20. The typed copy is there at page 18. My lord may see the photocopy of the original at page 20. It was I had to undergo treatment at GMC. Now, and I had to undergo X-ray. I have the X-ray plates with me as well. Now, my lord, the actual incident is reported by my mother, our mother, to both the Chanmari police station and women police station. My lord may come to page 24. This is my mother's intimation. They did not register any FIR, so therefore we intimated the SP, my lord, under the previous, now under 173(4). My lord, page 24, this is one FIR. I would like to inform you that I, Srimati Anima Sharma, aged about 85 years, wife of late Pitambara Sharma, resident of so-and-so. I reside with my younger son, Sri Prasanta Sharma, in my house. That is the applicant. On 6/3/25, my elder son, Dr. Diganta Sharma, who happens to be an NRI and a resident of New Zealand with his permanent residence at so-and-so Hantipur, Guwahati, had come to my residence in the evening along with his wife. At first, we started with a normal conversation. However, eventually, he started bringing up a recurring topic of property division regarding ancestral properties and started to quarrel with me and started giving me life threats if I did not transfer the said properties to his name. When my elder son, Dr. Diganta Sharma, charged towards me to attack me, my younger son, Sri Prasanta Sharma, had to hold him in order to restrain him from hurting me. If my younger son, Sri Prasanta Sharma, had not intervened and protected me, I would have suffered physical injuries and might have even that. That is, but anyway, it is not the first time that my elder son, Dr. Diganta Sharma, has committed such an act. He carried out such acts previously as well whenever he visited Guwahati and had assaulted me in 2019. There is no FIR to that effect, my lord, when he had come to Guwahati. He is also in the habit of filing false and frivolous complaints before honorable courts and police stations. I'm an aged lady, a senior citizen, and I am in fear of my life also. This is the actual event which has happened. Most probably the police has taken it to be a 161, has not registered an FIR. But my lord, this is the sections, my lord, under which it has been registered, my lord, are 296, 351, 374, and 351-2. My lord, 296, 351, 3 and 351, 2 are all bailable. It is only 74 which is not bailable of BNS. 74 is outraging the modesty. My lord, from a reading of the FIR, is there any allegation of outraging of modesty? Even if we take the FIR to be true, there cannot be any allegation of outraging of modesty. My lord, this is a fit case wherein, my lord, I suppose some protection should be given to me. And this is a property dispute between the family members. The informant is always in the habit. In fact, the earlier FIR of 2012, I have been acquitted, my lord. My lord.
Let them appear before the investigating officer. Case that an injury report not to call.
Heard Mr. P.D. Nair, Delaney counsel for the petitioner, and also heard Mr. R.J. Burwa, Delaney additional PP, appearing on behalf of state respondent. This is an application under section so-and-so in connection with so-and-so. Next para. It is submitted by Mr. Nair that the FIR has been lodged with some false and concocted allegations against the present petitioner. In fact, when the petitioner, rather, it is the petitioner number, it is the informant, he is the informant number 1. He is the informant number 1, who happens to be the elder brother of the present petitioner, had came to the house of their mother and started quarreling with them only on some property and there was some property disputes, and on that property disputes, and when he demanded the entire property, entire ostensible property, the mother of the petitioner raised objection, and to that, and for that, he tried to assault. When he tried to assault his mother, he raised it. The accused, he raised it the informant number 1, and for which, and in that process, the informant number 1 also assaulted him, and he sustained injuries, and for which he also had to take treatment in the hospital. But with some false allegation of assault, the present FIR has been lodged against the present petitioner, full stop. However, his mother visited to the police station and also made a complaint before the police station stating the actual incident, wherein the informant number 1 frequently used to come and wherein the informant number 1 had a quarrel with her and even tried to assault her on the property disputes. Next para, however, however, the petitioner is ready and willing to cooperate the IO in further investigation of this case if he is granted with some interim protection. Next para. Mr. Nair also submitted that all the sections are available except the section 74 BNS, but there is no ingredients at all to attract the section 74 BNS, which BNS against the present petitioner. Next para. Mr. Burva, the learned additional PP submitted in this regard, that the petitioner may be directed to appear before the IO and to cooperate in the investigation. In the meantime, the CD along with the medical report, if any, may be called for. Stop. Next para, interim protection. Okay, you'll be under interim protection for within 7 days you appear before the IO. Cooperate in investigation.
Deeply.
Mother CD is 441.
4. We are calling for the CD on 4/4.
Deeply.
Met leader.
Yes.
Yeah, FIR lordship will find it starts from page 12. And the relevant portion at page 13.
Yes.
Your lordship, on the basis of some secret information, narco checking was held and therefore lordship, 10.54 gram without cover lordship, heroin was recovered from the one showcase box which was kept in the pocket of the petitioner. That is the allegation in the present case. Lordship. Now already lordship, he is in custody for 42 days as on today lordship. And it is intermediate quantity, not commercial quantity. And considering the length of detention and the his already everything is been recovered and no other persons is alleged with the FIR. Considering that aspect, his fair may be considered.
Yes, does.
42 days as well. There is lordship, it is true that it is intermediate, but if CD may be called, I will try to come within a short period, lordship. So CD may be called for.
Where from it has to come?
It is from Boko, lordship.
Boko. Not so far.
On 26th, lord.
26th. Okay, we'll try to on 26th. 26th, yes.
Time being 22.
Time being 20.
Yeah, please, Your Lordship. Here in this criminal petition, my lord, I have challenged the proceeding under section 145 and 146, my lord. The proceeding initiated in the year 2023, my lord. Your Lordship may kindly peruse the order. Improved order is at page 31, my lord. That is annexure 5, my lord. Married me. Case record is taken up on transfer in my file. Peruse the police report forwarded by OC Katigora PS and petition submitted by Sri Abdul Ahad Majarbuya, son of Sri Kamran Ali Majarbuya, resident of such and such, against the Nuruddin, that is the petitioner, my lord, and Sohail and other persons for Latimara. Heard submissions of learner advocate of the first party at length on perusal of police report and on hearing of submission made by the learned advocate for the first party. I am of the opinion that the dispute between both the parties in respect of possession of disputed land may lead to a serious apprehension of peace and tranquility in the locality. In view of the above, I am satisfied to draw proceeding under section 145 CRPC and ask both the parties to file WS in respect of the claim over the disputed on the next date fixed, which is also fixed for hearing. Further, to contain the immediate threat to peace and tranquility, I do hereby attach disputed under section 146(1) CRPC and restrain both the parties from entering into disputed land until further orders, considering the emergent situation. This order is past ex parte. That ex parte order is that was passed on 6/1/2023, and it will continue my lord till date. And land-based property is really attached with the other. In the meantime, my lord, petitioner have submitted his objection, my lord, at page 32, my lord, type copy. Here, petitioner is praised for vacating the ex parte order of dated of 6/1/2023, but same has not been considered, my lord. Due to this reason, my lord, petitioner have approached before the session judge, my lord, in criminal revision petition for quashing of the entire proceeding, my lord. But as learned session judge, my lord, passed the order on, my lord, 31/2025 and dispose of the revision petition. Your lordship may kindly peruse page 46, para 13. Your lordship got it. In the instant case, it appears from the complaint petition and police report that there is a land dispute between the two parties and the dispute is purely civil in nature. Over and specified plot of land. Neither the complaint petition nor the police report there is any indication that anyone other than the parties of the dispute to the dispute had any interest in the dispute, or that the people in general of the locality were involved in the dispute and the land in question. Moreover, the instant case, the address given in the cost title of the complaint petition as well as the police report shows that both the parties are belongs to two different villages. Both the but the learned ADM point that the dispute between the parties in respect of possession of land in question may lead to a serious apprehension of breach of peace and public tranquility in the locality. Further, at the time of passing of the impugn order, the learned ADM did not decide the factum of possession of the land in question. Para 14, my lord. It is also pertinent to mention here that the impugn order dated 6/11/2023 has been passed ex parte, and the principle of natural justice also demands no one should be condemned unheard. Moreover, it is also appeared from the case record that there is no civil litigation pending between the parties with regard to the land in question in any civil court. There is no civil dispute between the parties, my lord, and civil litigation. There is no civil suit is also pending, my lord. Para 15, matter. Further, it is noteworthy to mention here that by the impugn order dated 6/11/23, apart from drawing by proceeding under section 145 CRPC in the case, land in dispute has also been placed under attachment under section 146 CRPC and restrained both the parties not to enter into the disputed land till disposal of the proceeding. It is well settled law that the order under section 146 CRPC is an interlocutory order, as the magistrate may withdraw the attachment at any time if he is satisfied that there is no longer any likelihood of breach of peace with regard to the subject of dispute. Moreover, in the instant case, disputed land is attached and both the parties are restrained from entering into disputed land until further order. In view of the matter, the revisionist was in a position to assess such order of attachment before the learned trial court, and also learned trial court, after hearing parties, was in a position to vacate the such order. In view of the such provision settled law, no revision would lie against such interlocutory order where the parties have to scope to approach before the against such order so passed by the learned court under section 146 CRPC. I have already approached before the learned court, my lord. That was unattended till date, my lord. And 2023 to 2025 now, my lord, my land is attached, my lord. And under section 146, my lord, your lordship may have found section 46, my lord. In provides so, my lord, here it is mentioned that the magistrate may withdraw the attachment anytime if he is satisfied there is no longer any likelihood of breach of peace with regard to the subject of dispute. till 2023 to 25, my lord, there is the attachment order is continued, my lord, and I have been suffering since, my lord, this land is my cultivable land, and I have been growing the paddy, my lord. And now due to the closure of my disposal of the revision petition, I have been suffering, my lord, since, my lord, I have not cultivating in the land, my lord. So I'm paid before your lordship, my lord. This is your lordship, may kindly state that we not
Oh, we have not said anything. You have submitted that one complaint or one representation was filed out from on your behalf.
My lord, to the
But that was not attended.
no unattended, my lord.
Unattended, remain unattended.
Yes,
The
sir.
question is that where from we are getting this? This is nothing is there. Only one petition here, copy you have annexed. So we have to call for the case record, entire case record. Now question is that you agree with the order of revision. So why, what is
No,
the
no,
reason?
not my lord. I am agreed with the, I am praying for your lordship, my kindly peruse my prayer, my lord. I have prayed for. quashing of the-
Now see, question is that he has rightly observed the Learned Divisional Code that it's an interlocutory order and there is scope.
My lord.
But after that order of the revision, have you appeared before the Learned Trial Court Bill or a Learned Magistrate with an application for this one? Because this copy is with you and there's a good observation made by the Learned additional session judge also. In regards to the provision also, that there is a provision, the magistrate at any time, at any moment, it can be, attachment can be vacated.
My lord.
Because as you have submitted, most probably it is also in the case because both the parties belong to another two different villages.
Two different villages.
And hence there may not be any reason for any things, breach of trust and all. For proceeding under section 145 or attachment under 146. Maybe somewhat there was a reason whether, I mean, ex parte order was passed. Purely civil dispute. So these observations are there, but thereafter, why don't you appear before the Learned Trial Court below with an application
Since, my lord,
for vacation of?
We have filed the application, my lord.
That
for-
was prior to revision, I think.
Prior to revision, my
Then
lord. That was
after-
unattended, and we have come before the revision court, but revision court ought to have considered that period length of the, my lord, attachment order, my lord. Since 2023 to 25, the attachment order is continued, my lord. And I.
Obviously, undoubtedly, it's purely an interlocutory order. That's
Exactly.
why we did observation. Okay, then we are issuing notice and we are also calling for the case record. Case record is from
Kachar, my lord. ADM Kachar.
ADM Kachar. And the revisional court also we have to call for.
Right.
Hard query, Mr. Swenson, and counsel for the petition. This is an application for quashing the impugn ex parte order dated 6/11/2023. Passed in case number 879 of 2023 by ADM Kachar Silchar, whereby proceeding was drawn up under section 145 and attached the disputed land under section 146 CRPC. Directing both the parties, not prohibiting both the parties to enter into the disputed land. Further, despite the present petition, the prayer is also made for quashing the judgment and order passed by the Learned Additional Session Judge number 3, Kachar Silchar, in criminal division number 194 of 2023, dated 30/01/2025, whereby the revision was disposed of without considering the period of attachment as without considering the period of attachment under section 145, 146 CRPC. Issue notice Koribo, also call for the case record from ADM to Koribo. We say additional district magistrate, you call for the record and also call for the record of the additional session judge in regards to revision petition. Both the records to be called for and also issue notice. List accordingly after 3 weeks will do.
After 3 weeks, my lord, in the meantime, my lord, at least my ex parte order 6/11/23 may kindly be stayed, my lord.
6/11?
6/11/23, my lord. That is ex
No,
parte
your petition is against this order only.
against the order of the
Revision.
revision.
We cannot stay order.
No, my lord, I am not calling for a staying of revision petition, but only praying for, my lord, the order of the ADM, my lord.
Now see, there are provision you have against the order of ADM, you have approached before the additional CGM or session judge.
Session
So
judge.
that's why no stay order can be passed at this stage. We'll hear the matter, we'll try to dispose of in the admission column, it's admission stage itself.
The date may be fixed, my lord.
3 weeks, after 3 weeks.
After 3 weeks, my lord.
It will come after 3 weeks.
Okay. Timing 24.
24 is also.
Lordship, petitioner has come up against the NPW order issued by the learned session judge, special judge Nalbari, my lord. Here, my lord, the POCSO case is pending against the petitioner, my lord. Cognizance was taken on 6/12/21, that is page 27, my lord. Page 27. Perfect. Thereafter, my lord, the learned court below issued summons, and my lord, finally he appeared, my lord, page 45. After receiving summon, my lord, page 45, he appeared before the learned court below on 12/1/2024. Page 45. Lordship has seen. Lord, thereafter he prayed for bail. My lord, bail was granted on 19/1/2024. That is page 46. And he was finally released, my lord, on 47, page 47.
Bail was granted on?
My lord, 19/1/2024. Because after appearance, as he was absconded, my lord, after appearance, he was taken to custody. And thereafter, he moved a bail petition that was granted, my lord, on 19/01/2024. Thereafter, my lord, on the next date, my lord, he appeared, page 48, 25/1/2024. Then, my lord, 19/2/2024, he appeared, my lord. Then next date was fixed on 11/3/24. On that day also, he appeared, my lord. Now, next date was fixed on 3/4/2024, my lord. On that day also, he appeared. And the case was fixed on 25/4/24 for evidence. My lord, on that day, my lord, 25/4/24, he remained absent, my lord. And the learned court below straightway issued NBWA against him. Now, my lord, his explanation for not appearing in the court is that, my lord, he is a labor, my lord. He went to Kerala for some days for earning his livelihood, my lord. And on that day, my lord, he was asked his advocate to take steps, my lord, on his behalf. My lord, that was not done, my lord. And the learned court below straightway, my lord, issued NBWA against him. Now he is ready to, my lord, face the trial. He came to know about the NBWA only when the police came to his house and informed his wife that NBWA has been issued and we are bound to execute it. Thereafter only, my lord, he has come before this honorable court, my lord. My lord, may I
Police
pray?
is also very kind to him.
Lordship.
Without arresting him, he just informed his wife.
He was not there, my lord.
Acha.
He was not there. Thereafter he came.
Okay, yes, that's.
Yes, Lordship, he is shown as an absconder in the circuit, Lordship. Then, Lordship, the trial court has been kind enough to, he has first issued summon, Lordship. Then at various occasions, he have not, without any steps has been there, Lordship. He remained absent. Then, Lordship,
No.
this NBW has been issued. So
Only
it is
one
according
day.
to law, Lordship. In my opinion, it is according to law, Lordship.
Only one date, my lord, he remained absent, and on that day itself, my lord, NBWA issued, my lord. Will appear, my lord, with a bail prayer, my lord, that may be considered in accordance with law. And will appear on or before, my lord.
When it is fixed?
24/3, my lord. On or before 24 will appear, my lord. Till that, my lord, NBWA may be statement, my bail prayer shall also be considered.
You are Mr. M.
M. Ali.
Heard Mr. M. Ali, the learned counsel for the petitioner, and also heard Mr. K.K. Das, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. Stop. Next part. Mr. Ali, the counsel for the petitioner, submitted in this regard that the present accused petitioner was shown as an absconder in the charge sheet, and cognizance of this case was taken on 6/12/2021.
Lordship.
And thereafter, on 12/1/2024, he appeared before the Planet Trial Court below, and he was allowed to go on bail on 19/1/2024. Since 19/1/2024, he was regularly appearing before the Planet Trial Court below. However, on 25/4/2024, he could not appear before the court below, nor any steps was taken against by his NDPS counsel. He could not appear before the Learned Trial Court below as he had to leave for Kerala to earn his livelihood. But as the NDPS counsel did not intimate him about the dates, he could not appear before the court below, and in the meantime, the NBWA was issued against him. However, he is still ready and willing to appear before the Learned Trial Court below and to contest the case, appearing on each and every date before the trial court below, if he is granted with some interim protection. Next, Mr. Das, the Learned Additional PP submitted in this regard that he was the conduct of the accused petitioner. So submitted that the accused was initially shown as an absconder in the charge sheet. However, the Learned Court below considered his bail application and allowed to go him on bail. But subsequently he remained absent without steps since long, and for which NBWA had to be issued against the accused petitioner, and thus no illegality has been committed by the Learned Trial Court below. Next one. Hearing the submission made by Learned Counsel for both sides, I have also perused the case record and the annexures file along with the petition. It is a fact that the accused petitioner was allowed to go on bail at the Learned Trial Court below on 19/1/2024, and thereafter he was appearing before the Learned Trial Court below and Learned Trial Court below. However, since 25/4/2024, he could not appear, and his NDPS counsel did not take any steps on his behalf, for which the NBW was issued against him. But it is also a fact that on the subsequent dates also the accused petitioner did not appear before the Learned Trial Court below, and for which the NBWA had to be issued against him. Thus it is seen that the Learned Trial Court below took the necessary steps for procuring the attendance of the accused, as he did not appear on several occasions, and the case was pending since long. Next para. However, considering all aspects of the case, I find that one chance may be given to the present accused petitioner so that he can appear and contest the case. In view of this, the accused petitioner is hereby directed to appear before the Learned Trial Court below on or before 24/3/2025, the date fixed for his appearance, with an appropriate application for regular bail, which may be considered by the Learned Trial Court below in accordance with law. Till his appearance, that is on 24/3/2025, the NBWA issued against him may be stayed or suspended.
Hello, let's
With above observation, this project.
for bail hearing, item numbers 33 and 34.
In this case, Lordship, though CD is there, it is not updated, Lordship. It need to be up to date.
Lordship, last time up-to-date case diary was called for.
But it is not there, Lordship. Regarding the statement, this statement is not there. The petitioner number, item number 34, Lordship.
Actually, that's why I was just asking you not to fix it day after tomorrow because 17/3 it was fixed, last date. And
That day he was not there, Lordship. PP was not there, Lordship. PP went somewhere, Lordship, who had gone through the case diary. Lordship. That prayer was made by the other PP.
Not somewhere, Lordship, in another court.
That was the prayer, Lordship. So at 2 p.m. other matters were fixed. So Lordship was not willing to fix at 2 p.m. So we prayed that it let it come on day after 2.
Oh,
that was the prayer.
But it need to be updated, Lordship.
In my case, Lordship, already 50 days behind the ballot. We did have 60 days mandatory, Lordship. In item number 34, Lordship. I was the first person to get arrested.
33 up to date. Okay, 33 is not updated. 34 is, in regarding 34, it is updated.
But
I'm the
33,
first person
34
to get
different.
But in the same FIR.
But then why of updated or not updated? I do not understand.
Update not updated because his statement is not there, Lordship. Though it is a bail application, Lordship. That is there, Lordship.
33,
In 33, Lordship, this Banjit Bora.
his statement is not available.
That is why, Lordship. It was earlier also called for. Give me some few days, Lordship. I will talk
But
to
how,
him.
he is an arrested accused.
Lordship, that is true.
Then why his statement is not available?
That is why, Lordship. I need some time.
But
Lordship.
now Mr. Munir has submitted
that
his
50 days.
petition, he is 50 days behind the bar. Cases are registered under which section?
Lordship, the sections are Lordship 61, 2, 318, 319, 336, and 316, Lordship. All are Lordship or 60 days mandatory, Lordship.
60 days. Your petition is behind the bar since when?
Lordship, 32 days as of today.
32 days. So whatever, that is other aspect, but the question is that why it is not updated, that is the question.
That is why, Lordship. Because
From
they are
where it has to come?
from Guwahati only. The cyber PS.
Cyber
Metro,
PS.
Lordship. I will talk to them, Lordship.
Personally, you talk to.
I will personally talk to them.
And in regards to 34, where Munir is there, it seems that he is 50 days behind the bar. So quite a considerable period he is behind the bar. If it is required, it's okay. If it is not required, it's not required. That is the case.
Required, Lordship.
Maybe required.
Lordship.
Then say, tell us when it can be fixed. And why your petitioner's statement is not available?
I am not aware about that.
Because he is in custody.
Yes.
On 24, Lordship.
24.
Lordship, I have been kept in police custody. I have been thoroughly interrogated. My statement, as per the instruction, I have deposed my statement. And also that there is one more thing, Lordship. Section 47 and 48 of BNSS is not here. It is not complied, Lordship. The ground of arrest is not communicated properly to me. In this case, Lordship.
That's why we need the case diary, in fact.
A short date may be fixed, Lordship.
24 he is saying.
24.
Before 24, we don't have any dates, in fact. 24 is next Monday, I think.
Lordship, Monday I have outstation case, Lordship. On Friday maybe, Lordship. This Friday it is in
Friday, again, same position, or Friday may not be available.
So I fixed on Monday, Lordship. It is the shortest.
Yes, Monday, at best Monday. You're going, you'll be outstation. Is there anyone in your chamber, other one, who can otherwise?
One will appear. Other one will appear, Lordship. Other council will appear.
Other council will appear.
You go on 25th?
On 24, let it be on 24.
24 we are fixing. You give the brief and brief the case also, so that he can appear, whoever appears.
Otherwise, I have been arrested merely on co-accused statement and nothing else, Lordship.
Maybe.
Nothing else.
Maybe. এটা hard করে দিব, এটা number 33 is a D Medhi, number 34 Mr. Munir. It is submitted by বাকি একে order হবে. It is submitted একে order মানে order sheet available করিব. It is submitted by Mr. Das, the learned additional PP, that CD is not updated and the statement of the accused petitioner Banjit Bora is also not available in the case record, case diary. Accordingly, he insisted to call for the updated one. Full stop. Let the matter be listed on 24. Would the matter be listed on 24? Same order. Okay, we're listing it on 24. Try to get the updated one, or if any instructions you can get that also will download.
I will talk it.
Obliged.
Much obliged, Your Honor. Much.
35.
My lord, although scan copy of call for my lord, but the same has not been listed. It is from Kamruk Metro, my lord.
It is from Kamruk Metro. You are Mr. J.H. Saikia?
Yes.
Heard Mr. J.H. Saikia, the learned counsel for the petition. From the office note dated 17/3/2025, it is seen that the scan copy is awaited now. Scan copy of the case record along with the CD is still awaited. Issue reminder, the registry will do the needful. List accordingly on 26 paragraph.
26, my lord.
Dio Paru, I don't mind. 26 well listed. Okay, well listed it on 26.
Oh,
What nature of case this one?
my lord, it is a
NDPS.
commercial quantity NDPS, my lord. But my lord, he is the driver of the vehicle, my lord.
Okay.
In that case, my lord, the owner of the vehicle has not been substituted.
Whatever.
My lord.
36.
This matter, my lord, NDPS case, my lord, I have counted, my lord, very few days, but let it be on 27, my lord. Because what happened, my lord, my friend has written he was arrested on 27/1, my lord. In fact, it's the wrong, my lord. 27/2, she was arrested. On 27, let her remain for 1 month.
We'll call for the update case diary, madam, because it is pending to collect the FSL report.
Okay. Heard Mr. N.J. Doctor, the learned counsel for the petitioner, and also heard Mr. R.J. Borva, the learned additional PP appearing on behalf of state respondent. And it is submitted by Mr. Borva that updated case diary needs to be called for as FSL report is not available. 20, you want insisting on 27.
1 month more, my lord.
27. Who matters? With prior Eid, actually, lots of matters have been fixed. In fact.
Fourth, my lord.
Let's have a, let's
No,
try.
Four, my lord.
4-4, okay. 4.
Only the problem is that, my lord, she was arrested along with her kid, my lord. Small. That's why I'm insisting on 27, my lord.
We'll be on 4-4.
4.
CD to CD, this CD, it can be returned back. Return back this case to calling updated one.
55 of the supplementary list.
In this case, my lord, I have been arrested on 23/6/2023. FIR is page 12, my. Kindly see the FIR.
You got arrested on
23/6/2023.
FIR is a page.
Kindly see, I have been acquitted with the original accused. Although, my lord, I am not the, nothing recovered from my possession. My lord, kindly see page 12. May I read, my?
Yes.
With reference to the above, I would like to inform you that today, 22/6/2023, at about 11:30 AM, an information was received from respected SP Karimganj that one suspected person who was driver of a Maruti Alto 800 was supposed to be traffic a huge quantity of drugs concealed in his vehicle from Mizoram and towards Assam. Accordingly, the information was recorded on Nagra Censored, and I was instructed to carrying out the operation of my accompanying staff. Accordingly, I have informed Inspector Deepak Das about the matter over phone, and he was duly authorized me as per the provision of section 42 of NDPS Act, and along with my team left to the conducted a Naka checking in front of Nilkantapur at 12:45 PM. This is also recorded by Nagra PS Sensor. The drug seizure kit comprising sensor. Next parameter. On reaching Naka checking point, we found suspected SP Sir Karimganj already present there with the team. After few hours, approx 3 p.m., we saw the said vehicle bearing RG numbers 10F1025 coming towards Naka Point and signal to stop the vehicle by our Naka team, and the vehicle was intercepted. We saw that one driver Khalid Hussain, that is me, my lord, let's so and so, sitting inside the vehicle, was thoroughly searched, but nothing was found inside the vehicle. Nothing was found inside the vehicle. Thereafter, the driver Khalid Hussain was interrogated at the spot, and then he revealed that he was escorting one vehicle bearing number so and so 8277 was coming from Mizoram towards Assam, and where concealed drugs. Accordingly, after a few minutes passed, we saw the vehicle AS-8277 was coming towards Naka Point, and our Naka team signaled to stop the vehicle, and it was intercepted. We saw that inside the vehicle, the driver along with another 3 people were in the vehicle. The driver Nitai Sarkar, so second my lord, Talab Hussain, Nitai Sarkar, so along with Talab Hussain, son of Shabbir Ahmad, and my lord Nitu Sarkar, and also Tahir Ahmad. These 4 persons, along with my another vehicle AS1025, one driver person, namely Khalid Hussain, led Samsul Haq at so and so. I, along with my team, immediately we rushed near to the vehicle and cordoned it and asked the driver to 2 others to come down. From the vehicle, one occupant, namely Talab Hussain, interrogated at the spot, and he told us that under the vehicle there were concealed suspected drugs under the secret chamber, and he was also agreed to lead us to seizure. He also admitted that the vehicle bearing number S0112 driven by Khalid Hussain so and so ahead of their vehicle, which was used for as a reconnaissance vehicle. Accordingly, we have collected few independent local witnesses so and so to present as witness of the search and seizure operation. We have identified them and saw our identity card. Thereafter, I conducted my self-body search in presence of the independent witnesses and proceeded towards the vehicle. Then I served 5 notices, section 550 of NDPS Act to the all apprehended person at PO. The occupant Talab Hussain showed us that the drugs were loaded in the secret chamber where it was concealed. Accordingly, in presence of the witness, I have brought tools and broke the said part thoroughly. After some time passed and after breaking the concealing of the secret chamber under the driver's seat and front seat, we recovered huge numbers of soap containing heroin concealed in the secret chamber and took out the same by hand. After that, we have found total 250 numbers of soap case containing suspected heroin inside the plastic bag. Accordingly, the seizure procedure started at about 5 p.m. The seizure items include so and so. These are total, my lord, gross total 3024.67 grams. My humble submission, my lord, from my vehicle, nothing was recovered. I have been implicated in the spot interrogation statement of the other accused person. And that other accused person's vehicle, the contrabands were recovered. So, my lord, and the fact is that the other vehicles, the other accused person from whom the contrabands were recovered, they were granted bail by Honorable Coordinate Bench, my lord. They have been granted bail. Talab Hussain.
Then, my lord, let the matter be placed before the same bench, my lord.
Yes.
If the coordinate,
My lord, that
bench is granted bail, my lord.
Coordinate bench is available.
Yes, that bench is not available now.
You can go through BC also, if it is. Suppose question is that you're saying that from your vehicle, nothing has been seized.
Nothing has been seized.
And the vehicle which were alleged to be escorted by you, from that vehicle, the contraband went seized. And out of that also, 3 petitioners were already, accused persons were already granted bail. So I think better to post it before.
Question is that, my lord, it was in his knowledge, my lord, that in another vehicle, my lord, that contraband was carrying, my lord. That is exactly the same case, my lord, the Mohit Agarwala, my lord. NCB versus Mohit Agarwala, my lord. Mohit Agarwala also, my lord, he identified the place, my lord, where the drugs were hidden, my lord. In this case also, my lord, he was apprehended because he was piloting, my lord. Because he was ahead, my lord. So that, my lord, he can inform the other person that if there is any police or no, my lord. But he was apprehended when he was questioned, my lord. Then he has said, my lord, that other vehicle is coming wherein drugs are there, my lord. That is, it was his complete knowledge, my lord.
And one thing in the sometimes we also in last 2 dates, I was there in Itanagar bench. From Itanagar bench also 2-3 matters were there. We dealt with the matters through BC. So you make a request before the registry through VC if it can be done.
So, my lord.
Otherwise, you are saying that obviously there may be differences in the judgment. I don't know what will be passed. I'm yet to hear your submission, but as you raised the question and you have submitted, there may be. That's why I thought that most probably it will be the correct hearing, if you can approach, because you fix a date at 2, at 3, or what is the convenient time of the court. Accordingly, that can be.
Your lordship may be reflected your order, my lords, in this regard. Your lordship passed the order in this regard, that that matter may be
Listed before appropriate bench.
Yes,
Okay, then that can be done.
a specific date may be given, my lord.
No, that
So
register will
that
fix one.
That because it will should be convenient for the court also.
Otherwise,
That's why.
my lord, I have been in
You
since
have
long.
to, no, you have to approach the registry for that. As because this was the appropriate bench, if I say, then you can approach the registry in that regard and tell us everything. Because I don't want that your petitioner should be deprived from any bail order and all. And as he is suggesting, there may not be, the position is constructive and consecutive, and two types of positions are there. So there may be difference in, that's why I thought that, I think that it will be proper, I think. So list corridor, item number 55, list before appropriate bench. As on a date to be fixed by the registry. You immediately today itself you can approach the registry.
And observation may be given, my lord, that I may be approached before the registry, and the registry may consider that.
Obviously you have to approach before the registry. Itu to likhibo নোৱাৰে আপুনি for the registry will fix it. Immediately today itself we can fix it. And even if suppose there is because last notification was there, if the bench which was dealt with the cases from the other side, if it is outstation, then it may be dealt by the other court also. That is the observation of the last notification was there. So complying with that notification, there may be another order for, but you just pray before the registry to list it in the appropriate bench. I think so. No? Okay.
My lord, my humble submission that observation will be given that I may approach today, and that may be arranged within 2 or 3 days. my lord.
Cannot be, that cannot be. How can it? Petitioner may approach the registry accordingly.
Obliged.
56.
If there is
Receipt?
receipt.
The petitioner, my lord, their husband and wife, they are behind bars in the last 36 days, my lord.
Both are
30
husband and wife.
Husband and wife, my lord. 38 days, my lord. As on today. My lord, allegation is that they have taken the photograph of somebody and my lord, they wanted to extort money, my lord, but this is not correct. If your lordship kindly sees, my lord, the conduct, my lord, as per the reading of the FIR, my lord, everything was pre-planned and pre-managed so as to bring them, and my lord, even before the filing of the FIR, my lord, they were taken into custody, my lord. And these were seized and there, but after the forwarding report, which is here before lordship, my lord, it shows that there were some manipulations there also, my lord. So at this stage, perhaps, my lord, after being 38 days in custody, my lord, all the sections are bailable, only one section is, my lord, non-bailable, that is, my lord, that allegation of extortion, my lord. So, my lordship may consider the grant of bail subject to what is the, my lord, series.
How many days? 38 days.
38 days, my lord.
But he is asking whether is there any materials for the. My lord, they being the reporter, my lord, they took photographs of the informant and his my lord girlfriend, my lord, in some my lord intimate position, my lord. And through this photograph, my lord, they started blackmailing, my lord. Initially, my lord, they took 5,000 rupees, my lord, from the informant. After that, they demanded, my lord, more money, my lord. Then the informant, my lord, he informed the police. Then the accused person, he was got red-handed, my lord, while accepting the money, my lord. So as far as
both the accused person.
Both the accused person, my lord, arrested on the same day. But as far as seizure is, my lord, when he received the money, 10,000 rupees, my lord, that is as far as seizure is, my lord, it is received by Kundan Borale, my lord, that is the husband, my lord. Petitioner number 1, my lord. So, my lord, investigation, as far as investigation are concerned, my lord, since they've been caught red-handed, my lord. So there are sufficient materials, my lord. So regarding the length of detention, my lord, that part I leave it to your lordship.
So that is their business. Otherwise, these two are the reporters.
These two are reporters, so-called reporter, Master.
An allegation, my lord, just to snare them, my lord. Nowadays, my lord, they go, they cover because they see, my lord, the informant himself says that he has an illicit relation with somebody. He was there in a dhaba or some sort of that resort, my lord. There they had, my lord, gone and they saw and they took the photograph. Now, my lord.
These are the private affairs. How can you?
My lord,
Actually, no.
we don't know, my lord,
It
what has
should
happened,
not
but
be.
this
In fact,
allegation about this money and all, this is not correct, because if your lordship kindly see.
Now, so there's a media trial also.
My lord, yes, that everybody, my lord, doesn't like, my lord. Then,
So
in the FIR and the forwarding reports, if your lordship will kindly see, my lord.
Yes,
there are
forwarding
some
report is that
differences,
page.
my lord. FIR is at page 15, my lord. May I place the FIR, my lord? With due respect, this is to submit you that before you that since 3/2/25, one Kumud Bharali, son of Sri Dharani Bharali and his wife, Porishmita Soikia, both residents of Christian Bosti and the Nagaon Federal Police Station in the district of Nagaon, introduced themselves as journalists of Annie Bharat and Northeast View and sent me a pen drive containing pictures of myself and my girlfriend, Ramjuli Gaunkhwa, in a comprising situation and demanded rupees 1 lakh initially and thereafter rupees 50,000. On refusal, I was threatened of the said content to be spread out in the social media and other portal web pages as a news and thereby defame me. After this, I advanced an amount of rupees 5,000 to them. However, not being satisfied today, they demanded rupees 50,000 and told me to bring the money to the old HP petrol pump of Jalagudi. As I did not have rupees 50,000 with me, I promised to pay them rupees 10,000 at the said agent place, being 20 numbers of 500 rupee note bearing serial number so and so, so and so. Accordingly, I informed the Jalagudi Police Observation Post and handed over the said money consisting of the said 20 numbers of 500 rupee note bearing the numbers as stated above amounting to rupees 10,000, and immediately the police arrived at the place of the occurrence at 5 p.m. of the evening and arrested them. So, my lord, thereafter, if your lordship sees, my lord, that FIR is, my lord, that is on 9/2/2025, my lord. It was given in the morning, my lord. And my lord, they were already taken into custody, they were already arrested, my lord. And my lord, lordship will kindly see the forwarding report, my lord, at page 27, my lord. There your lordship will see, my lord, that on 10/2/2025 at 11 a.m., Dhanjit Kumar Nath, son of late Devendra Kumar Nath, lodged an FIR at this police station. The complaint alleged that on 3/2 so and so the police persons, Kumud Bharali, son of Dhanibhar so and so, and he is there. So he says that, my lord, on 10, my lord, the FIR was given, whereas, my lord, the FIR itself suggests that it was filed on 9th. Before lodging of the FIR, my lord, these people are all taken into custody in a, my lord, makeshift, my lord, arrangement, my lord. And there were no money recovered, my lord. This money, I am told, my lord, the money was thrown to them, my lord. And, my lord, they came and, my lord, the police, my lord, they cashed these people, my lord. It was not a case of demand or nothing, my lord.
No, these persons were not on 10. 10, they were forwarded, in fact.
Yes, my lord. But here, sir, it says in the brief of the case, kindly see, on 10/2/2025 at 11 a.m., Ranjit Kumar Nath, so and so, lodged an FIR, my lord, at the police station. And thereafter, in the next page, your lordship will see the complainant informed the police personnel of Jalagudi PP under Mikiribeta PS, and at 5 p.m. on the same day, the complainant went to Put Jalagudi HP petrol pump and handed over the money. So, my lord, on 9th itself, my lord, everything was pre-planned and it was done, my lord. Thereafter, it was reflected to be done on 10th, my lord. Because the FIR says that on 9th itself, when it was lost, my lord, they were apprehended. So, the view is not correct, my lord. And that shows that there was some connivance, my lord, between these parties, my lord, to, my lord, take these people into custody for some ulterior motive, my lord. And, my lord, they say that the everything was done on
Connivance
the
in a
basis of a
sense,
pen drive, my
as you
lord.
were demanding money, so they informed the police and accordingly they were there, in fact.
But then it is not on 10th, my lord. It was on 9th, but they say it
There
was
may
on
be
10th,
some,
my
I
lord.
don't know.
So that is why, but moreover, my lord, I say now already 38 days in custody has been over, my lord, and there is no request from the police either for, my lord, custodial interrogation or whatever, my lord. In that view of the matter, my they also have a small child now who is residing with somebody else, my lord. So in that view of the matter, my lord, a lenient view will be taken and they may be allowed to be released on bail, my lord. And all offences are below 7 years, my lord. So mandatory period is 60 days, out of which 38 days.
Heard Mr. G. Chaudhary, the learned counsel for the petitioner, and also heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondent. this is an application under section so and so in connection with so and so. Next paragraph, Mr. Chaudhary, the learned counsel for the petitioner, submits in this regard that this is from the FIR and the forwarding report itself, it is seen that the petitioners were in custody prior to file lodging of the FIR, and thus it is a trap case wherein the petitioner, the respondents with the informants with connivance of the police officials had pre-planned to grab these present petitioners. Both the accused petitioners are husband and wife, and they are as a profession and they are reporter by profession, and has only a minor child, and there is no one to look after their minor child. Further, Mr. Chaudhary submitted that both the accused petitions are behind the bars since last 38 days, and thus the IO got sufficient time for their custodial interrogation. However, both the petitioners are ready and willing to cooperate in the further investigation of this case if they are granted with the privilege of bail. Next paragraph. Mr. Borwa, the learned additional PP, submitted in this regard that there are sufficient incriminating materials against both the petitioners who are, in the name of reporting, was engaged themselves in blackmailing the people, and the informant and the informant and his wife, and they took some photographs of informant and his wife in an intimate position.
Not wife, my lord.
Oh, not wife.
Some girlfriend. my lord.
With one girlfriend, and then they started blackmailing the informant to make it viral, to make the photograph viral, and in person to that, he initially paid rupees 5,000, and while he was on the second attempt, while he was to give rupees 10,000, the petitioners got arrested. Thus, he submitted that there are sufficient materials against the accused petitioners, and raised objection in granting bail to the petitioners. Next paragraph, hearing the submission made by learned counsel for both sides, it is seen that, and from the perusal of the case data, it is seen that there is sufficient progress in the investigation of this case, and both the accused petitioners are behind the bars since last 38 days, and hence, without going into other merits of the case, considering the length of detention, I find that IO got sufficient time for their custodial interrogation, and I find that further custodial interrogation may not be necessary for the interest of the investigation. Hence, I find it proper to allow both the accused petitioners to go on bail. Where it is pending?
Oh, my lord, sorry.
CJ Morigaon.
My lord, Mickey Beta, page number so and so. CJ Morigaon.
CJ Morigaon, to the satisfaction of CJ Morigaon. Okay, you are granted bail.
My lord, I am declared.
One, Mr. Biswas is appealed.
My lord, this man is in custody for 2 years, 5 months, and 21 days, to be precise. 2 years, 5 months, 21 days. He was arrested on 26/9/2022. Total number of witnesses are 11, and till date, 7 witnesses has been examined. My lord, he is behind the bar on the strength of a 67 statement. Statement recorded under section 67. Nothing was recovered from his possession. recovery in this case was made from one Alendro Ray. Alendro Ray, who is not the petitioner in either of the items, 1 or 32. Now, my lord, there were 6 total accused persons. Recovery was made from 1, that is Alendro Ray, and the 5 are arrested on the basis of 67 statement. Out of this arrested 5 person from whom no recovery was made, they were granted bail by a coordinate bench. The records are before your lordship. That is in BA number.
BA number 5.1. Item number 32, my lord. Both the record where the bail has been granted is available.
BA number kita koi dega. Udhar kyun baitha?
BA number I say, my lord.
BA number 2437 of 24 and the other is 478 of 2025. Both the files are before your lordship. Even one of the bail order I have annexed along with my petition, which your lordship may find at page 62. And if your lordship kindly turns to page 66, para 11, 12, 13, this talks of prolonged incarceration and violation of Article 21 and the judgments which were relied in favor of bail. And my lord, the coordinate bench thereafter, my lord, has allowed the petitioner to go on bail, my lord. Now, my lord, a similar allegation. Now, my lord, I'll also rely on a one-page judgment of the Supreme Court, which says basically that if on similar allegations, if the allegations are same, if one of the co-accused is granted bail, then ideally others should also be granted. But this is, my lord, though it is on anticipatory bail, but the principle is same, it is bail. 2005, 7 SCC 226. If the allegations are similar, then my lord, the benefit should go to all the accused persons. That's my submission.
Same submission, on the same day I was arrested, my lord. I along with Mr. Biswas client and 3 persons who were released on bail in the Artica car, my lord. Nothing has been recovered from the possession of these petitioners, my lord. And one, there is a copy. I have some judgment, my lord. Rest facts are completely same. Same day arrested, forwarding report same. Everything's the allegations are similar. I want to show one thing, my lord. He has already shown the bail order. I also give the second bail order, my lord, where Rupam De and Rubel Pal also released on bail, my lord. If your lordship go through the, my lord, page 1 to 10, my lord.
That is there on the record.
That is there of the record also. I also. And one important thing is that, my lord, he has already given the judgment of Kamalji Singh. That is here available. Another judgment in NDPS case, my lord, that same bail has been granted. In, my lord, 21 to 22, Anjan Nath case, my lord, where says that if the bail has been granted to one accused person, the similar circumstances accused has already released on bail, so the bail should be granted. That I am also mentioned the paragraph also, my lord. Para 3, my lord. In that page 21 to 22, 3, my lord, serial number 3.
21 to 22 of which what?
Judgment compilation I have given.
Acha.
I am reading that judgment, my lord. 21 to 20.
1. Rupam De.
No, my lord. That judgment name is, my lord, Anjan Nath.
21.
21, 22, my lord.
Rupam De is the co-accused of this case.
Rupam De is the co-accused who has granted bail. Rupam De and Rubel Pal, my lord. And earlier, Ratan Das was released on bail. We are all on same footing, my lord. We are not that. We are not all in the my lord. Anyway, my lord. from the truck of the Orlando Roy, the goods has been recovered. Yes, the substance has been, psychotropic substance has been recovered. I read that para 3, my lord. Page number 22 of the compilation. Taking into consideration the fact the similarly certain accusers already released by the, we are inclined to grant the bail to the petitioner. And I have also annexed some judgment of the apex court, my lord, where, my lord, stated that Article 21, when the Article 21 has been violated, and if your lordship discussed in your lordship judgment, many Amit Kumar case, I have annexed para 50, page 51, my lord. Anil Jadhav, my lord. Page 51, my lord. Your lordship kindly come to the page 63 of the compilation. Para 30. Have a lordship got it? So, considering all above aspects of the case, also considering observation made by the apex court in the various judgment as discussed above, further considering the facts and circumstances of the court, this court is opinion that period of long incarceration undergone by the accused petitioner for more than 2 years, 1 month may be considered as a ground for conditional liberty, whereas considering fundamental right granted under Article 21 of the Constitution of India. Therefore, without going into merit of the case, I am inclined to grant bail. Basically, all these things come from the Robi POCSO case. Your lordships know very well that there is a, my lord, embargo of section 37, my lord. There is a, my lord, section 37 said that a person cannot be released on bail if there is a reasonable ground for believing that he is guilty for committing that offense, my lord. That will go by the Article 31, Article 21. Article 21 is a fundamental right of the petitioner, my lord. When fundamental right of the petitioner has been violated, my lord, then, my lord, this too long incursion, then bail can be granted, my lord, without going to it. Although my case merit is, my lord, very good, my lord, because nothing has been recovered from the conscious person. Only on the basis of 67 statement, we made an accused person, my lord, everything. And in respect of 21, my lord, another judgment is there, my lord. Paragraph 32, my lord, page 77. All the Supreme Court judgment has been discussed, my lord, thereafter said. So, considering all the above aspect of the case, also consider observation made by the apex court in various judgment, as discussed above, further consider other facts and circumstances of the court. This court is opinion that long period of inertia undergone the accused person for more than 2 years, 5 months. We are 2 years, 5 months, 18 days. May be considered as a ground for bail on condition liberty, considering the fundamental right granted under the Constitution of India. Therefore, without going to the merit, I am inclined to grant bail, my lord. And, my lord, that principle has come, my lord. Huh? Huh? So, this is the, my lord. I want to show some judgment, my lord, from my lord. Lordship, kindly allow me to go, my lord, that judgment, my lord, of the appeal. Nitish Adhikari, your lordship has discussed what judgment have said Amit Kumar, and subsequently all the judgment is there, where 1 year, 7 months bail has been granted. Para 2, page 24 of that, para 3, my lord. Then subsequently, my lord, Soriful Islam, my lord, where 1 year, 6 months in the custody, my lord, that, my lord, bail has been granted, my lord. Secondly, Zakirul Islam, one case, my lord, page 27. 1 year, 6 months bail has been granted. So basically, this principle has come. I have given, my lord, your lordship knows very well. Para page 29, my lord. Basically, it was come from Muslim Ali Hussain, my lord. In that case, my lord, the Honorable Court has discussed this thing, my lord, that when fundamental right has been violated, then accused always inclined to grant on bail. So, subject to submission of my learned friend, my lord, if anything necessary, I shall add this, my lord. Otherwise, all the judgment is available, I know one by one. If your lordship go to the Amit Kumar case, every judgment has been discussed. And in other cases where the coactus is granted bail, my lord, I have annexed, my lord, page 1 to 10, my lord, all the judgment has been discussed. I think in item number 1. What was it? What's it here? Approximately note down some dates. In this case, the final complaint was filed on 21/3/2023. Charges were framed on 18/11/2021. 21/3/2023.
Charge frame.
Charges no, let's see, final complaint was filed, charge framed on 18/11/2023. Till date, out of 11 witness, 8 has been examined. Only his PW8, his chief is completed, cross is remainder. The next date is fixed on 26/3/2025.
Next date is fixed. Okay, when?
26th of March. These are the dates available with me also. Let's see, we now come to page 50 of item number 1.
Yes.
Paragraph 85. Role of present petitioner. Accused Jaydeep Mandal is the accomplice of the co-accused Rupam De, alias Raju De, Rajesh Devnath, Rubil Pal, Ratan Das, container driver Alinder Roy. As per the voluntary statement in connection with seizure of 517.080 kgs of ganja of Jaydeep Mandal, it is revealed that he, the petitioner, was trafficking of the ganja knowingly accompanied the other co-accused, namely Rupam De and Raju De, Rajesh so, which is clear in his voluntary statement and other corroborative statement of arrested co-accused Jaydeep Mandal. Also, will have to share rupees 2 lakh to pass the seized ganja from Tripura to Bihar. Then paragraph 3, accused Jaydeep Mandal is the co-conspirator along with other persons trafficking so and so. Then paragraph 4, the accused Jaydeep Mandal disclosed in voluntary statement recorded under section 67C of NDPS Act that he was consciously involved in trafficking of the ganja for money. His own statement. Then 5, telephonic communications between accused Jaydeep Mandal and accused Rubel have been established from CBR of accused Jaydeep Mandal. So this shows that they were in connection with each other. They were following the track from which the contaminant was seized. So these are the materials. And importantly, out of 11 witnesses, 8 has been examined. 8 has been partially examined. This is the fact. Regarding law, both the learned friend has submitted many judgments. Lordship, in my humble submission, only Muhammad Muslim and Ravi Prakash is laid down the law. Others are only orders, either 1 page or 2 pages. No law has been laid down in their cases. And Lordship, regarding long inclination, no definition has been given by the Honorable Supreme Court, which whether 1 year will be long inclination or 5 years or 6 years. If you go by Lordship law, in earlier IPC, CRPC, section 436, capital A, it says that 50% of the conviction is passed on, then they are entitled to bail. Here, Lordship, in case of NDPS, maximum punishment is 20 years. If we calculate that, then it comes to 10 years. Here, he was arrested on 26/9/22. Hardly 3 years has been completed by him. So whether we can say this is a long inclination. When 11 out of 11 witnesses, 8 has been examined. Whether the formula will be applicable in this case also. Lordship, I am relying on one judgment of Honorable Supreme Court here, Supreme Court in paragraph 39.
copy will be. I'm reading, I'll hand over copy to your lordship, paragraph 39.
Paragraph 13.
Paragraph 39. Merit laws. The upshot of the above discussion may be summarized as under. The provision of NDPS Act are required to be interpreted keeping in mind the scheme, object and purpose of the Act, and also the impact on the society as a whole. It is to be interpreted literally, not liberally, which may ultimately frustrate the object, purpose, and preamble of the Act. Then 2. While considering the application for bail, the court must bear in mind the provision of Section 37 of NDPS Act, which are mandatory in nature. Recording of findings as mandated in Section 37 is sine qua non in knowing for granting bail to the accused involved in the offences under NDPS Act. So this is my humble submission, Lordship. And rest, Lordship, I cannot dispute with the citation side before your Lordship. In my another submission, Lordship, in case of bail, there can be question of relative will not arise. Lordship has to see the facts and circumstances of each case and the circumstances where the trial is delayed. If the trial is delayed for whose defect, for whose either it is prosecution with defect or it is accused it has been delayed. But in my submission, there is no delay in this case because Lordship, out of 11 witnesses, 8 has been examined. Of course, 8 has been partially examined. This is my submission in both the cases. And in case of item number 32, page 70, Rajesh Devnath. His role has been as paragraph 84.
Seven zero, no?
Page 70.
Yes.
Paragraph 84, Rajesh Devnath. He is a petitioner in item number 32.
Yes.
Accused Rajesh Devnath is a part of criminal conspirator for trafficking of the 5.7 kgs of ganja. Accused Rupam De made plan with his associate and hired Maruti Ertigo car through his associate, namely Rajesh Devnath, for trafficking of the ganja. Rupam De, along with his associate, were following and escorting the ganja loaded container truck by Maruti Ertiga car from Tripura, and they have to go to Bihar to deliver the said ganja. Then 2. On the basis of his voluntary statement under Section 67C of NDPS Act and other relevant document of accused Devnath, it is established that the accused Rajesh Devnath is a part of criminal conspirator with co-accused personally, namely Rupam De, alias Raju De, Jaydeep Mandal, Rubel Pal, Ratan Das, container driver Alim De, and suspected supplier Sakil Islam, alias Sakil Islam, Srinivas Putradhar, and suspected receiver Raj. As per his voluntary statement under Section 67C of NDPS Act, it is clear that accused Rajesh Devnath was consciously involved in trafficking of ganja for money, and Rajesh Devnath will have to share rupees 2 lakh to pass the seized ganja from Tripura to Bihar. Then page 71. Accused Rajesh Devnath has disclosed in his voluntary statement recorded under Section 67C of NDPS Act that he hired the Maruti car bearing registration number so-and-so for following and escorting the ganja loaded container truck bearing registration number so-and-so from Tripura to deliver the same to Bihar. The next paragraph. On analysis of the statement of bank account of accused Rajesh Devnath, it is established that he has an associate in Bihar named Raj, receiver, who transferred an amount of rupees 90,000, rupees 12,500 in SDFC current account number so-and-so on 22nd September 2022 for delivery of the seized ganja 5.7 kgs, which was disclosed by accused Rajesh Devnath himself in his voluntary statement. This payment was made through UPI from SBI account in the name of Vivekananda Roy. The said transaction also clarified the involvement and relation of accused Rajesh Devnath with receiver Raj and other co-accused persons and suspected persons. Transaction between suspect Raj and accused persons Rajesh Devnath in account number so and so. This payment was made through UPI so and so. Then details been given. The telephonic communication between accused Rajesh Devnath and accused Rupam Dev. Also, Rajesh Devnath and co-accused Ratan Devnath has been established from CDR of accused Rajesh Devnath. CDR analysis also clarified the involvement and relation of accused Devnath with other co-accused persons and suspect persons. In this part of the criminal conspiracy, Rajesh Devnath was involved in associate, accused and suspect. So these are the materials available against both the accused. I have referred to lordship, and the position of the case till date has been submitted before lordship. This may have solution. In this case, since there is no long inclination, they are not entitled to win. Their application is liable to be rejected. Much related.
My lord, in support of his submission, the judgment which he has relied, that Kasif's judgment, my lord will see what was the length of detention in that judgment. The length of detention was less than 1.5 years. I've read that judgment. It is Justice Bela Trivedi's judgment, my lord. My lord, in cases where the court have rejected the bail of the, my lord, in all these cases, which the prosecution normally relies in these NDPS cases, in all these cases, there is one common thing, my lord, which I have seen. The detention period is below 1.5 years. I'm yet to come across a single judgment, my lord, where the petitioners are in custody for more than 2.5 years or 2 years or 3 years, and the Supreme Court has rejected by giving all this logic of Section 37 and all this thing, my lord. This Kasif and the other few judgments, my lord, which normally are relied by the NCB, in all these cases, the common, my lord, the common factor is the detention period was less. Then Supreme Court goes, my lord, to whatever little I understand, my lord, there is no hard and fast rule in bail, my lord. It's an absolute discretionary power, my lord. There are instances where 1 year, 4 months was at times are constituted as a prolonged incarceration. There is a judgment, my lord. I can straight away show, my lord, even in that compilation, the judgment I have seen has figured out, my lord. Because in the connected bail, my lord, I had given one compilation that can also be relied on. Even the index, I have given the time and everything. The period of incarnation is mentioned in the index itself. Your lordship need not even go into the factual details, my lord. Now, he has shown my involvement. My lord will see that those are all 67 statement. And my lord, telephonic conversation. My lord will kindly come to page 45, where the telephonic conversation figures out. Page 44. My lord is there at page 44. Now, my lord, yes. I am appearing for Joydeep Mondal, my lord. My lord will see page 44, Joydeep Mondal name nowhere figures out. Then page 45. Now, my lord, has page 45, yes. Only one phone call. Joydeep Mondal with Rubel Pal. One phone call. Rubel Pal, because this Srinivas is not an accused before this court, my lord. Only one phone call, Joydeep Mondal and Rubel Pal has been granted bail. Only one phone call, my lord. Can a man be charged under an NDPS Act on the basis of a single phone call and 67 statement? Tufan Singh has already, my lord, the courts have held that it is an inadmissible piece of evidence and which has been reiterated by our High Court in umpteen number of decisions. In umpteen number of judgments, my lord, that 67 is an inadmissible piece of. This is one. This is on the merit side. And that judgment, Kasif, my lord, I have already indicated. And one more thing, my lord. It is the next date of evidence is 29/3. I have also confirmed with the court records, my lord. It's not 23, but anyways, 4 or 5 days will not make such a big difference. That's my rebuttal. I'm declared.
My lord, kindly go through the objection petition filed by the, my lord, NCB, my lord. Page 168, my lord. I'm directly come, my lord.
there is an allegation, what has been mentioned, same my lord putting, or on the basis of 67 statement, my lord, I was made an accused in this case, my lord. You also can go through the same thing has been written on page 70 of my petition, my lord. Have your lordship got it? Yes, my lord. If your lordship go, my lord, Rajesh Devnath allegation, para 2, on the basis of voluntary statement recorded 67 NDPS, other 11 accused Rajesh is established that accused Rajesh is a part of conspirator with co-accused Rupam De, release on bail, Joydev Mandal, Rubel Pal, Ratan Das, release on bail, my lord. And important in transaction he has mentioned, my lord, which has been mentioned in para page 71, my lord, para 5. Have your lordship got it?
Yes.
Para 6, my lord, sorry. Para 6. Transaction between Raj, receiver and accused person, Rajesh Devnath, paying Karangapan Iman. This payment made through UPI SBI in the name of Vivekananda Roy. Vivekananda Roy is not accused in this case, my lord. How can he say that Vivekananda Roy? Nothing has been mentioned in respect of Vivekananda Roy, my lord. I have gone through all these things, my lord. And in respect of my learned friend has submitted that there is no judgment. My humble submission before your lordship is that, my lord, all the judgment, my lord, what has been mentioned, and all this judgment, my lord, in our High Court judgment also, in Supreme Court judgment, my lord, Article 21 has been discussed, my lord. Hussain Ara Khatun, first judgment, my lord, where Article 21 has been discussed. The thing is that, my lord, my learned friend has submitted what on the work for. As per my instruction, he is appearing before the trial court. No, not a single day accused has taken it. Adjournment, my lord. And in enough time they have taken the, my lord, adjournment, my lord. How can they say that we are the responsible? So this is my humble submission before your lordship. Considering, my lord, I am already given, he also given. They already co-accused is released on bail, my lord, Supreme Court judgment in Spain, NDPS other. And my lord, period of 2 years, 5 months, 21 days. Considering all this, your lordship may pass. And I have already annexed the one order, my lord, that upon he also annexed. And in my compilation, the other 2 persons, Rubel Pal, Rupam De, record is also available. That has been annexed. That is my humble submission. Sir.
We'll dispose of the matter with lengthy, so I'll give it in the chamber.
Lots.
I'll pass the order in the chamber. It will be a lengthy order. That's fine.
May it please your lordship. Lordship, this is 483 application. Petitioners are inside the jail, lordship, and lordship has dealt with the matter in item 28. Item 28 in the first half, lordship. Lordship has already dealt with the matter of the co-accused, lordship. He's the owner. Yes, item 28, and lordship was pleased to pass an interim order, lordship. Here, lordship, his employers who have been intercepted by the police during transportation, and they are the driver and handyman, lordship. Item 28 today.
Yes, I can.
Lordship has recollected.
Yes, obviously.
Yes, lordship.
He was a trader, rice trader with a
Yes, 21. He's the owner of the rice. Now, allegation was interim.
Yes.
Yes, allegation was that lordship that they could not produce valid document, and since lordship has passed an interim order in favor of the owner that he will going to. So these persons, they are the poor employee, lordship. They have been discharging their duty And they have been apprehended by the police at the time of Naka checking, Lordship. That is only the allegation. No sort of heinous allegation or any serious allegation against. Only they could not produce the document. That is why they have been taken into custody, Lordship. So
why don't you have not annexed any other documents here?
I have, yes, Lordship. I have in fact, I have also annexed this challan also.
Where? In
Yeah,
page
page
number?
21, Lordship. Page 21 is the bill of supply, Lordship. That was there.
Yes.
So my respectful submission, Lordship, no purpose would serve to keep them in custody. Since the master has already enlarged on bail and he is ready to cooperate and he will be submitting all the documents, this will be, Lordship, even unnecessary burden for the prosecution also detain them and feed up, Lordship. And the Ramjan month, I insist, Lordship, to enlarge them on bail with any condition. Local person, Lordship. Local person,
Short date
4% Lordship.
Short date may be given to doing CD.
I mean to
Can
say,
go to
there,
place.
or you don't have anything now with you. What I've sent in a while dealing with the item number, I think 28.
28.
Here the owner was there, the rice owner. And he was granted with interim protection so that he can appear and submit his relevant document. That is the trade license and the bill of supply was also there. So with that observation, he was granted. But here he is the driver owner of the case, driver and handyman of this case.
Handyman of the truck, Lordship.
So want to short date any?
Lordship may, because otherwise, Lordship, no purpose. Because if the master is the one who can answer, Lordship, they were only discharging their duty as per the dictate of the owner's, Lordship. So that was their, Lordship. Except that because they cannot produce any document and show on their part. What was available that they have given, Lordship. Nothing would come up, Lordship. Lordship may already question of even Article 21, unnecessary detention, Lordship. It will be only for the sake of detention.
You were not there, I think, while dealing with 28. Borwa was there or? Yes, yes. Yes. Okay. Monday, I don't think Monday will come.
Monday.
24 is Monday, 25 is key. Let it be on Tuesday then, 25.
Then 23rd, Budhbar,
26.
26.
Okay. Fixing.
Obliged, Lordship. Along with case diary, Lordship.
Yes.
I'm obliged.
2064 CD corporate.
38.
May please, Your Honor. The petitioner has already interim bail. He is appeared before the IO and recorded his statement.
He was an interim?
Interim. Not fixed for CD. Okay.
CD we have received, I think. Yes. What is in the CD?
My lord, basically, a truck with timber was found without any ID, without any owner. So, on the basis of some news publication, there was a suspicion with regard to the petitioner. So, he was sent a notice. Now he has appeared, but from the CD, Lordship, nothing adverse has come out. And the truck registration number, Lordship, nobody is claiming that truck, which was the origin of that offense.
You are Mr. Ding, yeah? A Burwa. Heard Mr. Huh? Heard Mr. A Burwa, the learned counsel for the petition. And also heard Mr. E. Portacle, the learned counsel appearing on behalf of, you are appearing on behalf of, no?
Standing counsel.
Standing
Forest.
counsel, standing counsel forest. This is an application of section so and so in connection with so and so. Last. So and so. CD receipt, where is the same, hard both side. It is submitted by Mr. Burwa, the learned counsel for the petitioner, that these two accused petitioners are innocent and they have not committed any such offense as in the FIR. However, after obtaining the interim pre-arrest bail on 3/1/2025, they have already appeared before the investigating officer and cooperated in the investigation of this case. Full stop. Their statement under section 161 CRPC has already been recorded, and they are still ready and willing to cooperate in the investigation of this case. Next para. Mr. Portacle is standing counsel for the Forest Department, submitted in this regard that they have already cooperated in the investigation of this case and considering the materials available in the case diary, their petition may be considered. So absolute corridor to 3/1/2025, there was an order that will become absolute. With the same terms and condition, if it is required, then you appear before the IO as and when it is required. Otherwise.
They're meant to confine to this case number only. R30 of 2024 to 2020.
There are some other cases also.
Some other cases are there.
Yes, this will be only confined to that order, that case only. Okay. Now you say case number, what is the case number?
R30 of 2024 to 2025.
Yeah, 9. Just repeat us.
R/30.
R/30.
2024-2025.
-2025. You're saying that it should be confined to this case only. In respect of so and so. Okay, we'll come back. Get a more so R25.
39.
May I please the motion? Worship, after filing this service, some development has been progressed. I kindly fix after 2 weeks, Lordship. He is not on interim, Lordship.
He was on interim. Not on
interim.
That is not after 2 weeks, my lord, because we have to retain the case diary, my lord. The fault that we fixed, my lord, since we have received the case diary.
You are appearing for the respondent number 2. Yes, we are going to retain the case diary, in fact. So maybe 1 week. Thereafter, why you need 2 weeks? File anything if you want, then file it within 1 week.
Actually, some development has been progress and I have to collect some documents. If I found necessary, then I have to file additional.
Because the other side is here only. I mean, the informant is also here.
At least 10 days.
He also may have some instructions, isn't it?
Okay, I'll have to get, otherwise, my lord, there is no other, I just received the request, my lord.
You are an amicus?
Amicus.
Oh, acha.
And that's a great one.
Okay.
Medical report was called for, which was necessary, Lordship.
We have received, I think, medical
received,
report.
My lord, but question is that my lord, how 183 statement has been recorded, my lord. When is he has implicated, my lord? 14 years old girl, my lord.
How many? 14.
14 years, my lord.
Okay, then we are retaining the case diary for 1 week only. Do you want any fixed date here or list after 1 week?
That is the fixed date, maybe fixed, my lord. Date may be fixed, so that, my lord, you can retain the case diary, my lord.
So 128, Lordship. If it possible, Lordship.
28 loss of matters have been fixed. Let it be on first, second, third, or fourth. Oh, that will be over, no?
28 then, my lord, please, 28.
28, lots of matters have been fixed, 28.
27 or something.
27 can be? 27, okay. List on 27, retain the case jail till next date of listing.
In the meantime, medical report may be called for the sure.
Medical report be called for. You can call for the medical report through.
My lord, my lord.
This prosecution is hereby asked to communicate with the IO to get the medical report. For fixing it on 27. Retain the case date till next date of listing. Okay.
40.
Wait, please, your lordship. It's the pre-arrest bail, my lord. The lordship will find the FIR at page 14, my lord, 14. Diagram. 14, my lord.
Yes. 14.
May I read, my lord? Respectfully, I beg to state that Moromi Khatun is my 14-year-old minor daughter. She was pursuing her studies by staying at her grandmother's house at so-and-so with her mother. Since last few months, the below mentioned accused number 1 started to follow my daughter, express his love for her, and asked her to love him. He also proposed marriage, but she refused the proposal. He then gifted her a mobile phone, which she refused to accept and returned to him. Subsequently, he threatened her and also threatened to kill her with the help of his group. She informed us about this. On 15/9/24, at about 7:30 p.m., while her mother and grandmother went to a nearby house for some work, taking advantage of her loneliness at home, the accused number 1 and his family member, along with other accomplices, entered her room, killed her by strangulation, and hanged her body in the house with a piece of cloth around her neck to make it appear though she had committed suicide. It is therefore placed before your honor to investigate into the matter and punish the accused number 1 and his accomplice accused person as per law. Now, lordship will find the names below, my lord. Raju, son of so-and-so, number 2, Abdul. The Raju is the accused number 1 who got arrested. And accused number 2, Abdul Malik, is the father of that accused number 1. And Ali Hussain is one of the neighbor, my lord. Earlier, my lord, this petitioner approached before your lordship, my lord, and the bail was rejected. And the lordship will find your lordship's order at page 21. It starts from page 20, my lord. The operative portion, my lord, page 22, paragraph 5, my lord.
Yes.
Mr. Bodua learned additional PP submitted in this regard that from the materials available in the case diary, it is seen that the victim had love affair with the accused number 1, who is already arrested in connection with the case. And so far, the material that have been collected by the IO, it is seen the accused number 1 is involved in the alleged offense. However, till date, the postmortem report could not be collected as report from the FSL is not yet collected by the investigating officer and is still awaited. So at that point of time, the postmortem report was not available. And the next page, my lord, the first line, my lord, next page, page 23. However, till date, mother of the victim and other witnesses are yet to examine by the investigating officer, who may be the vital witness for the prosecution. Further, he submitted that as per the instruction of all the petitioners are involved in the commission of the murder of the victim. Well, at that point of time of rejection, the postmortem report was not available. But subsequently, I also got the postmortem report, my lord, which shows, my lord, it is a oblique in nature. PMB.
9 p.m.
It is rejected on 21/1/2025, but the last date of entry is 20/10/2024. Before this, lordship.
2010 to 2025.
2010/2024, last date of entry in the CD, lordship, and it was rejected on 21/20/01/2025. It was on previous year, lordship. So it is not updated, lordship. Moreover, lordship, I have not found, since it is a rejection case, lordship, I have not found any new ground. And the postmortem is also that, lordship, has been there. What are new ground, Lordship? They have not described now. What are the new grounds on which this second application is there, filed, Lordship?
Lordship will see the first page, my lord, column 4, my lord. And our dark brown ligature mark, non-continuous, oblique, oblique, it's an oblique, my lord. So it's a case of suicide, my lord. And the case is registered under, my lord, the 302. The accused number 1, my lord, who was in
But
love
cause of death is still pending, no?
because of that viceroy. But so far, their contention is that, my lord, we killed the guard by strangulation and we hanged her, my lord. So therefore, from the PM report, it seems, my lord, it is a, my lord, non-continuous oblique. So it is a hanging, my lord.
It
That's
may be
true,
hanging,
one.
but the allegations are there in the FIR itself,
Allegation,
Lordship. In the FIR itself, it is after she was died, Lordship, then she was hanged.
But I just want to say one
Whether
thing.
any poison is
The
there or not, that is to be there.
21/01/2025, the order was passed. And you are saying that the CD is update, I
It is
mean,
before that order,
for 2410.
Lordship.
So obviously, if it is up to 2410, then this time also the statement of the vital witnesses are probably not there in the CD.
Not there, Lordship.
Because in the earlier observation, it was told, it was seen that those witnesses are yet to be recorded. And the postmortem report is awaited, but but the cause of death is yet to be ascertained. So do one thing, we need the case diary, because after your rejection order, there may be some development, there is statement may be there.
Yes, ma'am.
And that apart, the CD also does not contain this one because it was subsequent. You have obtained somewhere from the office. So updated one may be called for.
But till then, my lord, actually, my lord, so far it seems, my lord, the accused number who got arrested, he had a love affair, my lord, undoubtedly.
It is already observed also.
Yeah, observed also. So the father of the accused number 1 and the number 2, he is a neighbor, my lord. What connection do you have, my lord? And from the
I don't
PM
know, but
report,
there was an observation which was accordingly it was rejected. So
Yes,
thereafter there has to be something.
Yes,
So
madam.
you are basically on the postmortem and the other evidences. So
Yes.
we don't have these things.
And in fact, my lord, to be honest, my lord, to be fair enough, my lord, from paragraph 6, the page 22, my lord, it was rejected only on the basis of the submissions made by the advocate on behalf of the informant, my lord. The PP was fair enough, my lord. The PP submission, my lord, if your lordship goes, my lord, his submission was fair enough, my lord.
But this time the informant is not here.
The informant is not there, my lord.
But why?
We have not made them a party. We are not required to also, my lord. How? But in the initial stage, my lord, the informant appeared, my lord. So in that case, my lord, may I pray, my lord, interim will appear before the IO, my lord.
One rejected, interim cannot be.
And so
Yes, we can file
that's on the
it.
part of the prosecution, my lord. The diary was of last year, my lord. We have filed this application. We have.
Obviously, there is a lapse of prosecution.
This cannot be, my lord. And so far, my lord, this PM report is concerned, my lord. It clearly says, my lord, it is an oblique in nature, my lord. It's not a non-continuous, my lord. So it cannot be a hanging, my lord.
But the poison may be there, Lordship. The
Poison-
viceroy is there.
But the affair says there is a strangulation.
It may be.
Affair says there is strangulation, but strangulation is not there, my lord.
Anyway, Lordship, updated.
Mr. NJ Doctor, the learned concept for the district of return. I'm returning this one at this stage. Later on, if you need, you can sit. Heard Mr. NJ Doctor, the learned concept for the petitioner. And also heard Mr. KK Das, the learned additional PP, appearing on behalf of state respondent. CD received, but it is submitted by Mr. Das. That CD is, the last entry in the CD is only 24/10/2024. Which is prior to the rejection order dated 21/01/2025. Accordingly, he insisted to call for the updated case diary. Next para, Mr. Doctor, the learned counsel for the petition submitted in this regard, that this is a prosecution lapse. as the order of rejection order was passed on 21/01/2025 after perusal of the case diary, but even after lapse of more than near about 2 months, there is no entry in the case diary. Further, he submitted that till date the prosecution also could not collect the post-mortem report, though it has been collected by the petitioner by applying from the as certified by the police station. You are officer in charge.
Oh, yes, ma'am.
As certified by the officer in charge. In view of this, later updated case diary be called for, and the IO is hereby directed to furnish updated case diary along with the statement of the vital witnesses, PM report, and the chemical analysis report from the FSL. List accordingly when it can be listed.
27, look.
27 will do.
I will try, look.
Are you on
April 2, Lordship.
Let's try
April
from
2,
27, madam. He is saying it.
But it not come, Lakhimpur, Lordship.
It may not come, and there are lots of matters have been fixed, in
Yes,
fact,
madam.
on 27.
Otherwise, no problem. We are answerable to the client also, madam. At least we are answerable to the client also. That's why, madam.
No, 27.
27, if it doesn't reach also, madam, I have no problems. At least face saving, madam. At least. That's. Let's try, madam.
You will be able to. Because it has to be come from the Lakhimpur, not Lakhimpur, I think.
2nd April.
Yes, 2nd April will do. 2nd April.
Positive.
We'll try definitely.
I will try, Lordship. I'm applying.
You also communicate with the IO regarding the FSL report also, chemical analysis.
For orders, item 41.
This is complete.
My lord, it is a bail my lord, pending appeal, my lord. Already more than 3 years already gone, 10 years conviction, my lord. The sentence 10 years, 376. Almost going to be half, my lord. So without going negative, I am only at this stage, my lord, because there is no chance of hearing my subject to what my lord say, my lord. And own family, my paternal and uncle.
Paper book is also ready, in fact.
Paper is ready, but normally we find, my lord. This court order several times came, my lord. You have to kindly see the order shoot, my lord. Several times it has come. Even orders also does not reach. There is no possibility of hearing, my lord. Otherwise, we are otherwise ready, but there is no chance, my lord.
On hearing day, why don't you take?
16/5 paper was given, 16/5/24.
16?
16/5/24, we received paper. Even then, thereafter, matter is not coming for hearing.
In 5.
They
Oh,
can-
you have received.
Yes, we have received mine. It was
So it
supplied
may
to us.
come because it's an appeal of 2021.
That's
exact.
not, even now the 13, 14, 15 appeal is still pending, mine. So there is no chance, my lord. So I
Because
think.
paper book is, we are not in a position to hear the matter on the bail, in fact. Have
No.
you furnished your objection also here?
Yes, objection.
Because if bail will be heard, then matter can be heard, because in the bail hearing also we have to analyze the statement of the witnesses, etc. Is there any material?
Yeah.
So that's why I'm saying, do one thing, Mr. Chaudhary. If I fix it on suppose on a hearing day, why don't you remind us, because it is a jail appeal and not jail appeal, but
Not
the
jail.
person is in jail.
Not jail.
So that may be
No,
considered.
I
like
was ready, idea also, my since paper was initially, my lord. 5 months, almost 7, 8 months paper was already prepared. Matter is coming, but not reaching, my. Last 2, 3 days it come for orders, my lord. Then ultimately it was fixed today, my. Honorable Justice, yeah.
I mentioned. Respondent is also there.
No, this one name is there, last time they appeared also, my. On their back,
Yes.
it was fixed, my lord, today.
Hearing call number fixed going.
I believe,
But I think we come in due course. In this case, every day they are listing in all the courts. They can declare something. But due course means basically the person is behind the person's last 3 years.
More than 3 years.
More than 3 years.
Abraham.
That is the one.
Why do you Lord may consider bail as Supreme Court decisions are also there, my lord?
Hearing this option, hearing this. All upon common heat of water. And now see prior Bihu 7, 8 up to 10, most probably there are lot matters have been fixed. Will it be possible for you to after Bihu any day?
What I am,
Top of the list it
what I am
can be.
submitting subject to your worship, my lord. Bail can be considered
No, no,
subject.
bail hearing, that means total hearing. We will have to hear the entire matter. Because everything has to be assessed. That's what.
But the substance is centered in 10 years.
22nd of April.
Wow.
22nd will do. 22nd April. Before prior Bihu, I don't.
Let us see, my lord. Let us see if possible.
And then again, it will again go back. And that's why.
Bihu, my lord, it may be 10, maybe there, 10. Thursday, my lord.
And Thursday. Indeed, asylum. Top of the list, COVID minimum. Mr. So-and-so Corridor, assisted by Mr. Ayu Chaudhary. And also heard Mr. Harji Burwa Corridor. Service is completed, paperwork is ready. List the matter along with the list the matter in the list the matter in the hearing column. And preferably on the top of the list. List accordingly on 10th of April. So and so.
If for any reasons hearing my lord is not taken up, bail may be considered, but otherwise, your lordship, so many judgments that your lordship is aware, I did not remind my lord. 4 years, 5 years, almost 50%, my lord. Nobody they are entitled to get it.
It's a 10 years.
10 years, my lord. Own paternal uncle, my lord.
Not yet 5 years, nah.
No, that's true, my lord. But that the Supreme Court says, my lord, it is not fixed term of 50%. It depends on the case to case, my lord. But your lordship, I should not say your lordship is that.
Okay, then we are fixing. Let's see.
Then my
we'll try it. 10th of April, nah. I will still remember. We'll make a note here also.
Obliged to us. Obliged.
And just make a mention in the morning hours, so that matter can be fixed at 2 or at.
Whether lordship will be on that date, my lord, somewhere else I do not know.
I cannot say at this stage.
Happy if it comes.
If it is on 10, suppose I say in the morning hours, if you say that preferably, I mean, it can be upgraded. So at 2, if it is can be fixed at 2, at least.
Yes.
If it is
Not
given
even
part shot
much,
also.
madam, a victim and some informant that.
Yes.
Obliged.
Just remind us.
Obliged.
Then people.
42 and 43.
May I please?
Yes.
Service completed in my case, my last 42, my lord. The 3
Service is completed.
Completed, my lord. Respondent number 2 appeared, my lord.
You are appeared now already. Achha.
More in my case, my lord, 42. Respondent number 2 appeared, my lord. And
42.
42, my lord.
42, who is respondent appearing for respondent? You appear for the respondent. 43. So service is completed.
Completed, my lord.
Here, do we need any paperwork preparation or?
My lord, 3 accused persons, my lord, sentenced, my lord, convicted, along with the, my lord, these two accused persons. Earlier, the main accused person was already granted bail by this application.
No, we are not going to hear the bail matter.
My lord, that is why, my lord, earlier, because of service
No,
not
do you want to
completed,
submit any, you have furnished any bail, objection?
No, lordship, not required 5 years.
What was the term of sentence?
5 years.
5 years,
5
my
years.
lord. 5 years.
5 years. So
Earlier,
you may not file also. Okay.
the dividend bench, my lord, in the POCSO case, the
No,
10
no,
years, my
whatever.
lord, it was also, he was, main accused persons was allowed.
So you are going to file any objection here or what is your?
45, no objection.
Huh?
43, I have no objection with the opinion. Another three. 43, I mean,
What is nature of case? This is 376.
376, my lord, only POSCO, my lord.
POCSO
but
is also there.
also
So
there.
you don't have any objection in POCSO also.
Because my lord, they convicted under.
Why? Arriba, misunderstanding. What was the age of the girl?
Below 17 years, my lord. And then the
Anyway, you don't
doctor-
have any objection in a POCSO case.
My lord.
Very nice. And then you?
There is no POCSO trial except any accused person, my lord.
The accused person.
In 43, no POCSO is added. Was there?
42 also, my lord. 42 also no POSCO.
344.
Sentence on the basis of section, my lord, 360 and 374. No POSCO case, my lord, upon ask, my lord.
Huh?
Charge frame, my lord, earlier. But the learned trial court sentenced the court accused person under 366A, 344 and 34, my lord. But there is the ingredients present in the case, my lord. Prosecution
Okay.
case is not
Okay,
sufficient.
okay,
my
okay,
lord.
go for
It
it.
is why, my lord.
Yes, 42, start 42. You are on 42?
42, my lord. Page, my lord. Page 17, my lord. Medical officer, my lord. Page 17, my lord, paragraph 10, my lord. My IA criminal matter 1073, my lord. Maybe page is my lord.
Yes, page?
Page 17, my
Oh. You're insisting on IA.
my lord.
No, IA page number?
IA criminal, my lord, 1073, my lord.
Yes, page number?
17, my lord.
17.
17, my lord. Paragraph 10, my lord. Officer, my lord. Medical officer stated in his examination sheet that on 25/4/2003, he was working as medical and health officer 1 at Silapattar Model Hospital. And on that day, at about 11:58 AM, he examined the victim who was brought by the journalist secretary of Silapattar PS, and he examined the victim after taking formal consent from her in presence of Romi Setia's GNM. And the following, found the following. There was no any injury on her genital area or part or her body, my lord. Opinion. PW stated that after the physical examination and laboratory report, there is no any evidence, any forceful sexual evidence and violence on her private parts and her body. And according to X-ray report, the age of the victim was below 17 as pregnancy test was negative, my lord. Next, my lord. PW7, my lord. Brother-in-law of the victim, 14, my lord. 19, page 19, my lord. My lord. 14. PW7, brother-in-law victim stated in an examination that in the incident took place about 1.5 years back, and his sister-in-law victim pursued his study staying at his home, and at the relevant time, she was a student of class 10, as about 15 years, and one day at about 9 PM, the victim went missing from his house, and later on, he came to know that the victim had eloped with the accused Vishwajit, and he informed her mother about the incident, and accordingly, they started searching for her, and then complaint was lodged before the police. During cross-examination, my lord, this is important. PW7 stated he did not know whether the victim girl had love affair with the accused Vishwajit, my lord. Next, my lord, PW8. PW stated in his examination sheet that the incident took place 2 years back, and that he heard the victim had eloped with the Vishwajit, then got married, my lord. Married, my lord. During cross-examination, PW stated that he knew that victim guard had eloped with the accused person, my lord. PW9, my lord, 16. PW9 stated in his cross-examination sheet that the incident took place about 2 years back, and that the victim pursued the study staying at the Notundole home. And at the relevant time, she was student of class 10 and she heard that the victim had eloped with the accused person. My lord. During cross-examination, PW stated he heard the victim heart was taken away by the accused persons. PW10 stated in his examination sheet that the incident took place about 1 and 2 years back, and the victim was studying in the place of house of the brother-in-law and heard that the victim got married with the, and he also had the complainants file her parents, my lord. The only, my lord, PW themselves stated that she was not kidnapped, my lord. The girl eloped with the boy, my lord, because of love affairs, my lord. In the affair also lost, my lord, after 1 month after incident, my lord. There was also no explanation of the affair lost that 1 year, after 1 year and 1 month, my lord. My lord. And the affair also stated that he was threatened and kidnapped by the, my lord, the victim girl was kidnapped by the 3 accused persons and near the jungle with a meat dog. The meat dog was not recovered, my lord. And in from the one shop also, the shopkeeper also not examined, my lord. And there was no jungle, my lord. The shopkeeper, my lord, in the place of occurrence, my lord. And the informant also stated that, my lord, he does not know what was written in the FIR, my lord, also. She also, the informant mother, my lord, also does not know what was written in the FIR, my lord. Considering the all facts, my lord, there was no basis of the filing of the FIR, my lord. The basis of the informant, the FIR on basis case was on the basis of purely on falsity, my lord. The incident took place on 24/3/2016, my lord. Lost more than 1 month, my lord. 25/4/2016, my lord. So, my lord.
Yes.
Stress, my lord, prima facie, there is no criminal motive in the case, my lord. Only procedure there is something infirmities in the judgment and trial court. Will be allowed to go on, and they will face the trial, my lord.
Oh,
So, my lord, because
yes, who was appearing on 43?
I am here for 43, my lord. There is one problem, my lord.
You are the main accused, Biswajit.
No, my
no,
lord.
Biswajit
Biswajit Dole was granted bail by the Honorable Division Bench, my lord.
No, Biswajit, where is the Biswajit?
He was
He's already.
Yes,
you
he
are
was
appealing for whom?
convicted for 25 years.
You are for?
I am for, my lord, Marge Kuli and
Family members.
no, my lord, co-accused, my lord.
friend, my lord.
Friend, my
Friend,
lord.
lord.
Friend of Biswajit.
You are also a friend.
Yes, my lord.
Here, my lord, one problem was arised, my lord. That, my lord, for Laban Pegu, my lord, he also filed appeal, my lord. He also filed appeal, my lord, for Laban Pegu, my lord. Item number 42, my lord. I have also filed, my lord, for Laban Pegu, my lord. There is 2 petitioner in my petition, my lord.
No. 42 is for Laban Pegu.
Yes, my lord.
And
43, my lord.
Not for Laban Pegu. You are for Megre Kuli.
Here is 2 petitioner, my lord.
Huh?
Marge Kuli and Laban Pegu, my lord.
And
I have to
43 also 2 petitioners.
Yes, ma'am.
Both
How it has come?
Yes,
How-
my
how?
lord. That is, I have filed, my lord, earlier than this, my lord. Now they have filed, my lord. Now I can strike out, my lord, for Laban Pegu, my lord. But I
So
have
you
filed
don't
earlier.
have any information, earlier information you didn't
No,
have.
my lord, but because my lord, relative, relative nephew, my lord, come, my lord,
Approach you.
my lord.
They have given
If you have the-
Okalatnama Us also, my lord.
Maybe they have taken in the jail, my lord, jail, they both signed, my lord.
Yes.
The
In one
relative
Okalatnama, both the accused
photo
has filed.
petition.
Therefore, we have filed, my lord.
Subsequently relative. One of the relative present, my lord. One problem.
If they are go, I can strike out for Lobon my lord. My lord, I am for.
So your submission will be basically on Megrekuli.
Yes, my lord. My lord. Here, my lord, Biswajit Dole was granted bail, my lord, by the filed by the informant one affidavit, my lord, on the basis of this is the order of this, my lord. He was convicted for 25 years, my lord. That's the Honorable Court granted bail. He was convicted under POCSO Act.
He was under POCSO.
Yes, my lord. Here, my lord, medical report also, here, phase 3, my lord, kindly come to para 4, my lord.
Phase 3 of your
No,
of
my
your
lord.
IA.
Yes, no, my lord, in court judgment, my lord.
Acha, in judgment.
Yeah, this, my lord, everything, my lord.
But in para 40, item 43, you're not filing any IA.
No, I have not filed. No,
So why you are doing?
I have 43, I have filed, my lord. I have for bail, my lord.
Acha, one IA is also there.
Yes,
Okay, okay. So you are insisting what? What to say?
Order of Biswajit Dole bail, my lord.
Biswajit Dole.
It is phase 3, my lord. Para 4. It is submitted that the evidence of the medical officer does not support the version of prosecutrix, both in her statement under section 164 of the CRPC as well as PW1. The evidence of the mother as PW5 also does not support the allegation made against the applicant, and there is no mention of any sexual assault. PW7, the brother-in-law PW8, PW9 had deposed of the victim's elopement with the applicant. Here is the elopement. The PW10 had also deposed the hearing that the victim got married. The age of the alleged victim has also been questioned by the learned counsel while referring to the deposition of PW11. That, my lord. Kindly come to my lord, para 9, my lord. Page 4, my lord. The learned counsel for the applicant has tried to bring the inconsistencies in the allegation and also the aspect of delay and elopement. On the other hand, the learned APP has submitted regarding the consistency in the persons of prosecutrix. This court, however, noticed that the respondent number 2, who is the informant in her affidavit, has categorically stated regarding misunderstanding of the situation. For ready reference, the relevant part of the affidavit is extracted
So
here.
here also you have filed your affidavit?
Yes, they have.
Affidavit you have filed?
One affidavit has been signed, my lord. Signed.
No, not signed filed by this informant.
Yes, my lord, informant.
In 43. And whatever 42? No, not same. We have filed affidavit here also. এইটোতো এনেকুৱা নহ'ল দেখোন, দেখাত বেলেগ হ'ল যে। একেখন কৰিছে নেকি? One affidavit for both. Thank you. This is the original. You have the original, or you have filed already. Acha. Here we have this. This is also with the record. You have filed in the record also. These are. These are available in the record also? No.
No, not it.
Yes, then.
That is, my lord, case, my lord. Already, my lord, main accused, my lord, who was convicted for 25 years on the basis of affidavit, he was granted bail, my lord. By the
He was
honorable.
convicted under POCSO also.
Yes, under POCSO also.
And your conviction is?
5 years.
No, 5 years. Where is the order of conviction?
366, my lord. 366, A, 34. and 344 and 34. In my in my criminal appeal, my lord, page 50, my lord, in criminal appeal, my lord, this order. Criminal appeal, my lord, page 50, my lord.
Yes, I have seen. Okay, that is, yes.
Lordship, victim is consistent in her 164 statement, Lordship. And evidence of the victim is also corroborated with 164 statement. And PW 1, Lordship, the victim testified that she was coming from the show on that day, on that fateful day. And 3 persons by threatening her with meat-down grabbed her and took her inside the jungle and committed rape on her. And PW 2, Lordship, was told the same by PW 1, and PW 6 come to know from the victim that three person dragged her, and one committed rape on her, and other was watching it, Lordship. So foundation of fact is established, Lordship, and PW 1 corroborated with the PW 2 and 6, Lordship.
And your submission? Only due to?
And the bail to market. Okay, the FIR was filed misunderstanding, and that's already settled the IIT outside.
Okay, same submission from your side. Do one thing, order এটা almost একে হবো, খালি যেটো 43 you are saying, na?
Yes.
Margaret Cooley and Loban Pegu was
Yes,
also
yes.
there. It will focus on agote 43. Come to 43. But Mr. M. Kalita did not counsel for the applicant. This is an application that we will under section so and so for suspension sentence. Pass against the right, whereby the present applicant were convicted under section 366A, 344 by 34 IPC, and they were sentenced to undergo RI for 5 years.
Yes.
And to pay fine of rupees 5,000 for section 366A by 34 IPC in default of payment of fine, RI for 3 months. And to RI for 3 months. And further 1 year, and on further sentence with 1 year RI for section 344 by 34 IPC in default payment of along with fine of rupees 1,000 in default, RI for another 1 month. Next part. Mr. Kolita further submitted in this regard that initially he filed the application appeal on behalf of 2 petitioners appellants, that is Magri Huli alias Devakanta and one Laban, no?
Yes.
Laban Pegu. But it has learned subsequently that said Laban Pegu, the applicant number 2, no?
Yes.
Applicant number 2 had already approached another council and his case is already filed by another council which has already been registered as criminal appeal number 376 of 2024. And accordingly, he submitted that the name of the applicant of the appellant number 2, Laban
Pegu.
No, sorry, Laban Pegu may be strike out accordingly. Next para. It is further submitted by Mr. Kalita that learned counsel for the applicant that present accused petitioner is innocent and he is no way connected in the alleged offense, though he was convicted under section 366A of the 344 by 34 IPC. Before it is submitted that there is no medical evidence, submitted that from the medical evidence of the doctor, it is seen that there is no sign of injury found on her private parts at the time of examination, or nor there found any recent forceful, or nor there found any sign of recent forceful sexual intercourse while examining her. All the other PWs, that is the PW7, PW8, and PW9, corroborating to each other, have deposed that the victim girl had voluntarily eloped with one Biswajit Dole, the appellant in the other, one Biswajit Dole, and out of love and affairs, and they stayed together accordingly. More so, the informant herself stated in her examination that she is not aware about the contents of the FIR, and rather it is stated that the FIR was lodged only due to some misunderstanding of facts, and to that effect, she also sworn an affidavit, which is also placed before this court through the engaged counsel. Yes, you are Mr. G. J. Goswami, appearing for the respondent number 2. আপুনি আগতে এবাৰ লিখি দিব জে কলিতা তাৰপিছত NN দাস MS NN দাস আৰু J Goswami for respondent number 2 লিখি দিব আগতে ফাৰ্স্ট লিখি দিব so and so. Mr. Kulita further submitted that it was alleged that the victim was kidnapped by 3 persons, that is the present applicant along with 2 others, showing a mid-down from the jungle near to a shop, but surprisingly said Middow was not seized in connection with this case, as well as the shopkeeper was also not examined to substantiate the said fact. Accordingly, it is submitted that there are sufficient grounds. Accordingly, it is submitted that there is sufficient probability of acquittal of the present applicant and succeeding in the connected appeal file along with the present application. In connected appeal will लिखी रहले हो every probability of succeeding the connected appeal will be. Where your petitioner was bailed to the entire period of
Yes.
trial.
No, he is in bail in trial period.
Trial, he was on bail. Further, he submitted that his petitioner was on bail during the entire trial, and he never jumped over any condition of bail. And further, he is ready and willing to provide sufficient security if he is granted with bail by suspending the sentence imposed on him. Full stop. Next para. MS thus, the learned additional PP submitted in this regard, that from the evidence on record, it is seen that the victim is consistent throughout her victim is consistent in every stages of her evidence oblique statement. And she clearly testified that she was kidnapped by 3 persons, showing Midtown, and out of which accused Biswajit Dole committed rape on her, though she did not bring the allegation of rape or sexual assault or penetrative sexual assault against the present applicant. She accordingly submitted that there are sufficient incriminating materials against the present applicant, and accordingly raised objection in allowing the accused petitioner to go on bail by suspending the sentence imposed on him. Next para, Mr. Goswami, the learned counsel appearing for the informant, submitted in this regard that the informant has submitted that the informant has no objection if the accused appellant is allowed to go on bail by suspending the sentence, as the case oblique FR was lost by her only due to some misunderstanding of facts. And to that effect, she had already already sworn an affidavit stating that she has no objection if the petitioner is allowed to go on bail. Full stop. Next para. Considering this submission made by learned counsel for both sides, and also considering the fact that the informant of this case has no objection in granting bail to the present petitioner vis-a-vis the other materials placed before this court, and also considering the conduct of the accused petitioner during the trial, I find it a fit case to allow the present petition, and thereby the accused appellant, namely Megre Kuli alias Devakanto, is hereby allowed to go on bail to reset for rupees 50,000 with 1 CUT, 20,000 with 1 CUT of like amount, to the satisfaction of where it is
Learned special judge POCSO Dhemaji.
Learned special judge POCSO Dhemaji, and the judgment and order dated so and so, passed by learned so and so, is stayed oblique suspended till the disposal of the connected agreement. With the above observation, the present IA stands disposed of. The apne POCSO, your good name. একেই থাকিব দুইটা অৰ্ডাৰ, খালি এটা JP Chauhan থাকিব হা ইটুত নাম্বাৰ আইটেম নাম্বাৰ 42 JP Chauhan for the response number 2. Mr. Saikia na your S Saikia will be for the applicant, and NN Das will be. বাকিখিনি observation একে থাকিব except the observation of deleting the name to খালি বেলেগ থাকিব, বাকি একে হ'ব না? অকল striking out the name of one Leban Pegu from the petition item number 43 to khali beleg hobo, The rest will be same. But that will be, that is no need for mentioning in the item number 42. Can you follow me what I'm saying? 42 and 43 will be same order. As there was an observation that Megre Kuli alias so and the Laban Pegu was the applicant earlier. So Laban Pegu, name of the Laban Pegu will be strike out from the so. This portion will not be there in the item number 42, rest will be same.
Yes. Abhilash.
Both the matters have been disposed. I disposed. Main case of Ketya. Main appeal to the Ditobo be fixed accordingly for hearing in due course. Itu kon rakhi thebo amar.
$44.
The pending criminal appeal, IA has been filed before this open, my lord, where the accused has been sentenced to undergo rigorous imprisonment for 10 years under section 6 of the POCSO Act.
Here state has filed their written objection?
Yes, actually, state has filed objection because Amicus curiae has been appointed.
No, state has filed objection.
Objection has been filed, my lord.
We have received the LCR here.
Basically, on the ground, my lord, first of all, my lord,
No, that's the second. Where is the your objection?
Objection.
I have not seen here, but otherwise filed. We have not received the objection here.
Maybe down in the record it is not there.
Let it come on the record then, Lordship.
And any objection, you're from side?
Finally heard and disposed of matter.
That's true, that's what. It is a case of I 2024 only.
It is case of 22,
22,
my lord. For more
Your
than 4.5
petitioner
years.
is behind the bar since?
Since the date of judgment, your lordship, that is on 4.5. That is, it was on of 19/4/2021, my lord. 4 years, 2 months.
Let it be heard finally, my lord. Immediately.
Lordship.
Because I think in the main appeal, your lordship may kindly see my date of hearing may be fixed, my lord.
Oh, it's 27 is already listed.
Yes.
For hearing.
So let it come on that day.
Okay, then. List accordingly, the matter may be listed for hearing. On 27/3/2025 as already fixed. No, I will pass the IA order only. IA 27/3.
Yes, we can.
IA
Along with the IA.
No, 27/3 is already here.
Hearing. Yes.
Then I will pass the order.
Yes. It may come along with that.
I liquid list accordingly, list on 27/3/2025 along with the criminal appeal number 40/2025. Will be hard finally.
Yes.
27, by the way, 27 is the hearing day?
Yes, ma'am. This is Thursday, ma'am.
Thursday. Okay.
Yes.
$45.
May it please, Lordship. My lord, I have filed this criminal petition for quashing of the FIR, my lord. The petitioner before lordship is a elected Panchayat president.
No, why it is in outer column? Service is awaited.
Service is awaited, but my lord, they are not coming, my lord. Problem is that, my lord, there is no stay order, my lord. The proceeding is going on.
Whatever, we are not going to hear the matter. The question is, it is in order column. I am asking where it is in order column.
My lord, today I only pray for consideration of my interim prayer, my lord.
No.
Lordship, may kindly see, I have taken step, my lord. I have seen the office note, my lord. I have seen the office note reminder is also sent, my lord. So they are not turning up. So today, my lord.
Your address is proper?
Address is proper, my lord. Address is proper, my lord, never, my lord. Never, my lord. Only quarrel was taken for due to a misunderstanding, my lord. We filed the FIR page number 10 earlier, my lord, that was registered, and the police visited our house and took a statement of her relative, my
You
lord.
can have pray for your interim in the at the stage of motion stage. We generally pass the order at the motion stage.
My
No,
lord,
I'm not
notice
going
was
to pass.
issued, my lord. Notice was issued
Yes, yes,
till next date, my lord. Till next day, it may be vacated on the next occasion, my lord.
Let my notice may be third party.
Now the question is that he is taking step, but it is returned unserved. That is the problem.
They will not come, my lord. Because never position, my lord, is that she is Asha Kurmi under head department, my lord, opposite party. He will not, she will not come.
Through magistrate.
Through magistrate also.
My
It is
lord,
also noted, my
one
lord.
another, my lord.
Lordship may kindly see
Through
the
by
office
registered
note.
court was also taken, that was, my lord, returned as answered. And through the court of the, my lord, honorable magistrate was also stepped, but regarding that, my lord, no report has it come. My lord.
It is noted.
Till now, it has not come. Can it be evaded or can it be pass an order for through judicial police station? That also can be done, concerned police station.
Yes, that can also be done, my lord.
Otherwise, he is saying that they are the neighbors.
Yes, yes.
They are neighbors, na?
Never, my lord. The problem is that the trial is going on. Next date is fixed on, my lord, 5/4. So before that, we are praying for either interim or final disposal, my lord. Because the petitioner is a public representative, he is a concert president, my lord. He is not in a position to go to the her office. That is a totally false case, my lord. Nothing
We
is there,
don't
my
know
lord.
whether false
And the
or
lordship may kindly see only one page, my lord, page number 44 only, my lord.
No,
Only
I'm not
two
going
lines.
to hear the matter. That's why.
Because, my lord, the petitioner is granted bail, my lord.
Very good.
Duly appeared and granted bail. So he will not go anywhere, my lord. So today, my lord, till next date, may I pray for consideration of my interim prayer. Further proceeding may not be there, my lord. That much, my lord.
You are Mr.
Yearly.
Heard Mr. A. Ali, the learned counsel for the petitioner, and also heard Mr. P. Botaku, the learned additional PP, appearing on behalf of state respondent. From the office note dated 17/3/2025, is in that the scan copy, neither the scan copy nor the unserved notice is returned to the office of the registry. Full stop. Issue reminder to call for the scan copy of the case record. Registry will do the needful. Further, considering the submission made by learned counsel for the petitioner, it is hereby directed to take fresh steps on the respondent through judicial police station. Please the matter. Your petition is fixed on 5/4.
Fixed on 5/4. That is why, my lord, so early date, my lord.
কিবা date আছে জানো? Date নাই কি কৰিব? 2, 3 will open by 3 is open in this. 3 is open in this. Date is fixed on 3/3 then? 3rd of April. Okay, 3rd of April.
3rd of April.
Yes. 3rd of April.
Oblige lordship.
46.
Yeah, please, your lordship. Lordship, notice upon exponent number 2 has been completed, lordship.
Completed?
Yes, lordship. As per lordship, to process server, lordship. So, official. It is on supplementary file.
Amicus may be appointed.
Yes, Amicus may be appointed, lord.
Heard Mr.
So, PK Das, well.
Heard Mr. You are Mr. PK Das, no?
Yes,
So, yeah.
lordship, PK Das.
Heard Mr. PK Das, the learned counsel for the petitioner, and also heard Mr. P. Botaku, the learned additional PP, so and so. From the office note dated 12/3/2025 and from the supplementary file, it is seen that the notice is duly served on the respondent number 2, but no one has represented the respondent number 2. Accordingly, can you tell us Amicus or registry will appoint otherwise? Accordingly, registry is hereby directed to appoint an Amicus to represent the respondent number 2. List the matter. LCR, we need LCR here?
LCR is already
received.
Received. LCR has already been listed. List the matter accordingly. After 1 week we'll do. After 1 or 2 weeks, I think, na?
2 weeks, ma'am.
2 weeks will do better, I think.
Yes, ma'am.
List after 2 weeks we'll do. Okay. List after 2 weeks.
Oblige.
47.
May I please, your lordship?
Yes, of course.
Lordship, this is a petition for quashing an FIR, lordship. Case diary was solved for us. And we have taken steps, lordship.
Notice.
Item number 47.
Now we have taken steps. On the respond number 2, it is remark is that the addressee left. As per your instruction, whether it is true or he is still there, he or she,
I
whatever.
have to take instruction, lordship, regarding that. Because we know.
However, the district service report from the district magistrate is still awaited. So want to await till next date or what to do?
Okay, date may be given, lordship, and the case diary probably not there, lordship.
We have
Case diary
no case diary not received.
Yes, no case diary not yet received. Let the report from the court may come, man. Already.
Steps have already taken on 23rd of January 2025. Heard Mr. K. Thakur, the London Council for the petitioner, also heard Mr. P. Thakur, so and so. From the office note dated 23/01/2025, notice on the respond number 2 issued to register post return unserved with a remark, invert command will address left. However, the service report is still awaited, sent through the district magistrate Kamrup M. Full stop. Let the notice be awaited, service be awaited till next date of listing. Also issue reminder to call for the case diary. List accordingly after 1 week. You all are insisting for fixed date. What to do? Now see the condition.
Any fixed date. Then after Bihu vacation. Maybe after Bihu, lordship. On 23rd of April.
20.
48.
Yeah, please, ma'am.
Yes.
And take the affidavit file that might have flag A, madam. I have filed one affidavit, madam, flag A, madam.
Flag A.
Yes, madam. My lord, in this case, notice was issued, and my lord, I have collected the article consignment number from the registry. And my lord, the track consignment reports are, my lord, what may take up the page 49. Page 49 is with regard to respondent number 2, my lord. These are the postal tracking consignment reports, my lord. My lord, so all the respondents are served, my lord, and my friend is appearing for respondent number 2, my lord. So in this case, lordship note that the service complete and it may come up for admission, my lord.
Altogether, how many respondents are there?
Total 4, my lord. 1 is a state, 2 my friend is appearing, 3 and 4 I have submitted the postal tracking consignment reports. It says that, my lord, the consignment delivered, my lord.
So Thakur cases of 406 and 420, I think, na?
Yes, sir.
Case diary was also confirmed.
They have made some personal allegation against the respondent number 4. So, respondent number
Service to complete visit.
4 have to appear before the reportation by pointing someone.
Cases 3 and 4, you cannot appear for 3 and 4.
Yes, sir. Because they have made some personal allegation.
But 3 is officer in charge of Tinsukia.
Since
4 is SI.
Yes, sir, investigating officer. Since there are some allegations, that's why I made the, but main respondent is respondent number 2 in a state, my lord. There as a formal party, my lord, since there are some allegations.
But how can you say that these service cannot, I mean, consignment report is there, but the question is that these two are the.
Case diary is otherwise available.
My lord, lordship may fix it for admission, my lord. Case diary is there, my friend is there. Lordship may hear the matter.
I'll get the instruction.
Because the consignment report says it was delivered.
Received.
Heard Mr. A.K. Gupta, the learned counsel for the petitioner, and also heard Mr. P. Thakur, the learned additional PPAPM on behalf of state respondent, and Mr.
J. Das
appearing for the respondent number 2. It is submitted by Mr. Gupta that he has already filed one affidavit after obtaining the track consignment report in regards to the notice issued to the all the respondents, wherein from it is seen that the consignment was duly delivered to all the respondents. However, the respondent number 3 and 4 did not appear in spite of receiving the notice, and accordingly he submitted that the service may be deemed to be completed on respondent number 3 and 4. Next, Mr. Botaku submitted in this regard that case diary has already been received. Next, post-op, that the matter be listed in admission column, and considering the track consignment report, it is held that the service is completed on respondent number 3 and 4. List accordingly. After 2 weeks, we'll do.
Can it be on 3, 4, your lordship? Senior counsel, Mr. Bidatu will come from team. So
He's from outer station.
3 and 4, lots of matters are there. How it will not reach?
Let it be on 4th, my lord, then.
4, 3, 4 matters have been listed.
But my lord, there is no
Third
state.
pariboni, no space. Many matters are there. Even some matters are already been fixed for particularly on those who are dead. Not be possible. Daughter is coming.
Yes, he comes after verification.
After verification, we'll do otherwise.
My part, because my lord, the police is harassing my lord. Each and every day they are asking the petitioners.
We don't have any sound now. See, 3, 4 prior ED is completed. 3, 4, 5 full. Yes, 5 and 6 or whatever you can take. A weekend. These are the weekend day. Then 10th. Monday is 10th. 7. 7
Let
can
it
be
be
at
on
best.
7th, my lord.
7, whether we will be able to come on 7th.
Second,
My lord,
third, and fourth.
he can do through the VC also, my lord. Sometimes
Second,
he-
third, and 4 will not be possible. Not possible.
He can do through the VC also, my lord. Sometimes he appears.
VC against voice crack is there's every possibility problem and disadvantage. is
Let
there.
it be 4th, my lord. Let us try. my lord.
Fourth, we cannot give it you at all.
Immediately after verification.
Immediately after verification.
Yes. On
Immediately after verification.
22nd of April.
22nd of April.
22nd of
22nd of April. full day.
But, what-
Ask Mr. Dutta to accommodate on 22nd of
Yes.
April.
Oblige.
49.
May I please, your lordship?
It should be.
My lord,
Modification.
this IA is arising out of a revision, my lord.
This is for modification.
Modification, my lord.
Modification will not be here. It will be appropriate bench. Otherwise, who passed the order, in fact?
My lord Justice.
Justice
M.K.
Karita.
Pandit.
Okay. Registry is hereby directed to list the matter before the appropriate bench. After 1 week.
50.
Same, my lord.
50 also same. Same modification is required.
Same modification, same applicant.
Same order, 1 week.
Oblige.
51.
Lordship, allow us 2-3 days time to obtain instruction.
So one IA is there in connection with BA.
Yes, this IA is for extend because that cancer patient, my lord, online I have done when your lordship was in Itanagar bench, my lord.
So it was extended to?
No, it was temporarily extended and because they took time that day, my lord. So it has again, the IO has not been disposed of. So they are taking, the IO has not been disposed of because your lordship was of the opinion that when your lordship will come to the principal bench, then your lordship will take up the IA because they wanted to file some objection on that day. On that day, they took time.
No, I was for what, in fact?
IA was for extension because initially the bail was
No,
granted.
that was extended to all that day.
My lord,
Through VC, I have heard for
Lordship,
4.
it was extended till 19.
till 19, till today it was
not
extended.
disposed of.
It was not disposed of. Then your lordship, because there was some audio problem that day, my lord. And my friend, Mr. Kaushik Jain, he appeared and he sought time for his senior to appear. Then your lordship said that since there is some audio issue, so I will hear the IA.
Oh, IA is pending.
So I will hear the IA and therefore.
IA is for extending.
Absolutely, my lord. Now, today they are praying for time, my lord. Let them take time. My only predicament that may not be 2-3 days, at least because again I'll have to obtain certified copy. Already twice I have obtained certified copy. Let them take some time, maybe 10
Take
days
some
time.
time.
No
10
hurry,
days,
my lord.
15 days time.
10 days.
15 days. Aji tarikh ki
Because otherwise I have not the other aspects of the case, but he is, as reported, he is a cancer patient with the leukemia. That is, if you have any objection in extending the, you can file, but take at least 10-15 days time.
At least 15 days. Let it come after Bihu, my lord, on 22nd.
Before Bihu.
Bihu to 12th to Bihu shuru ho jayega. After Bihu thak na.
Let it take after Bihu because the patient, he is under treatment. There may be any objection on your part. I am not on that. So, Lipok, heard Mr. M. Biswas, the learning counsel for the applicant, and also heard Mr. MS N. Kakuti, the learned counsel, appearing on behalf of Mr. S. Sikai, the standing counsel NCB. Next para, considering the submission made by learned counsel for both sides, let the matter be listed on 22nd, you are saying?
22nd, Tuesday.
22nd of April 2025. Until then, the interim bail granted to the applicant, public petitioner, wide order dated 11/12/2024, comma, passed in bail application number 2427 of 2024, shall remain extended.
I'm deeply obliged.
52.
So in this matter, in the last date, a date was fixed by the honorable court. It was 3/4, but inadvertently in the order it was mentioned today's date. Both the sides were agreeing to 3/4 for final hearing, your lordship.
It's a final hearing, lordship.
So on the day,
3/4.
yes, your lordship. On the day,
Perhaps by mistake comes orders column, I think.
No, not in orders column. 52 is hearing column only.
hearing, but the date is mistakenly given today. Because on 3/4, because senior counsel Mr. B. Datta will be coming on that day. That is why it was fixed on 3/4 by Justice P.J. Sekia, sir.
I'm on behalf of SC Vishwas, lordship. I was not there.
On the other day which we have fixed for data, what was the date in last?
22nd April, your lordship.
22nd of April.
The consent was taken for 3rd of April, so
That
again,
day he was present.
yes, that day he was present, and today also.
See, matter may be listed, but I don't think so because 3rd April, there are lots of matters have been fixed. Because there were some prayers and that was already considered. Prior Eid also, lots of matters have been
Yes,
fixed,
sir.
and after Eid also 2nd, 3rd and 4th, I think.
Yes, sir.
Those 3 days, lots of matters have been fixed. So if already consent is there, we can fix the matter, but we cannot say at this stage whether hearing can be possible or not.
Yes,
That's what
at
I'm
least
saying.
we
That's
can-
why I just asked
Yes,
you what was the other date.
Yes.
That is on 22nd.
22nd.
Lordship, 6 to 7. No, sir.
No, his counsel is not here, na? He is coming from outside, that's why. Mr. Datta is coming from outside, that's why.
So let it be on 3rd of April. We'll try our luck, your lordship.
3rd is April is what? Hearing day?
Hearing day.
Thursday. It won't reach. I'm just telling you, it won't reach. I think. There are matters, it is of 24 matters, 20 other matters are also there. আগতে দি থৈছে আহে একো নাহে না। No, they insisting on 3rd because consent was taken on 3rd. Because somehow it has reached.
On the last day also, it was in the before the court also we have agreed there on 3rd. But why
Taking the
it was-
dictation and all, most probably there was an hearing. 3rd quit on it, yeah. Okay, we'll fix it on
Yes.
3rd. Let us see what happens.
Interim to continue, lordship.
Somehow it may reach also, I
Yes.
don't know.
Yes, your lordship.
Okay. If it reaches by 3 also, then also it will be possible for our
Yes,
part to hear the
Today,
matter.
nowadays what happens is computer they automate they sort it by year wise. So since it will come as a last item only.
Last item, 2024
Yes,
matters.
yes.
That is one thing. Okay, then due to paucity of time, matter could not be heard. List on 3rd of April.
Interim to continue.
Interim was there. Interim be continued till next date. Okay.